May I please, Lord?
Yes.
My lord, I beg to pray for listing on criminal appeal with a criminal IA for bail, my lord, on 23rd, my lord.
Next week on a date to be fixed by registry.
My lord.
Yes, next.
Yeah, so I beg to mention here item number 62, Lord. So here I have filed one additional affidavit that may be kindly called for, Lord.
All for the addition.
Of Lord.
May please, Lord, I'm praying for listing of a criminal revision for motion next week, my lord. Any
Next week on a date to be fixed by registry.
much obliged.
My lord, I have a similar prayer, Lord, for listing of a
Similar order.
of like
Lordship, with respect to item number 44, petitioner is interim, we need to update the CD.
Who is for the petition?
Lord.
Heard.
Actually, as per your lordship, he had cooperated with the 44.
AV.
Heard Mr. A.K. Hussain, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who prays for some more time for producing the updated case file. The prayer is allowed. Let this matter be listed on 27th October. You are on interim.
Hello.
The interim order shall continue till next week.
Hello.
May I please, Lordship, my lord, item number 33 and item number 49, service report is awaited. 33 and 49,
Proxometer.
POSCO matter, my lord.
Heard Mr. I.A. Talukdar, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Learned. We will await service report.
Wait.
It appears that the notice issued to respondent number 2 has not yet been served. Learned additional public prosecutor is requested to get information regarding fate of the notice issued to the respondent number 2 from the officer in charge of jurisdictional police station, and let this court know about the same on the next date fixed. Let this case be listed on 17th of October. Item number 30,
33 and 49, my lord.
33 and 49, same order.
May I please, your Lordship? Lordship, I beg to mention one AB number 2104 of 25 for listing on Monday, madam, for withdrawal of the case.
Okay. Okay.
Monday, madam.
Okay. Yes,
Like also back to mention for listing of a criminal appeal, my lord.
next week on date to fix by registry.
Yeah, please, Lord, I beg to mention item number 55 and 56, your lordship.
Yes, what is your prayer?
Kindly, your lordship, this matter will be taken up at 2, your lordship.
No. Wait for your turn. Why at 2?
Your lordship, this matter has been listed on 3rd of September. your lordship.
Wait for your turn.
Lordship,
Wait for your turn.
I beg to mention item number 37. Can be adjourned for the day.
Miss, what is your name?
M Medhi. M Medhi.
M. Day
M Medhi.
and Medhi. Learned
Scan copy also not this in
learned counsel for the heard Miss M. Medhi, learned counsel for the appellant, learned counsel for the petitioner who prays for an adjournment. It also appears that the scanned copy of the trial court records have also not been received. Hence, issue reminder for the same. Let this matter be listed on 22nd of October.
May I please, your Lordship? Lordship, I beg to mention for one criminal petition admission matter next week.
Next week on a date to be fixed by registry.
May I please, your Lordship, I beg to mention criminal petition, my lord, motion matter, my lord.
Next week on a date to be fixed by registry.
So Lordship, that's why I'm praying for listing of one criminal petition. Lordship.
Next week on a date to be fixed.
Prepare for another criminal.
Both next.
Deeply okay. Lordship, I beg to mention item number 23. My senior counsel is out of
20.
23.
What is your name?
Lordship,
What is your name?
I, Basumutari.
Heard Miss I Basumutari, learned counsel for R Basumutari, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty of the
Arvind Singh.
conducting counsel for the petitioner. The you have informed the other side.
Lordship, I try to inform the other side, but cannot contact.
You have to inform. PP, you inform the other side also.
You take the phone number from the file and phone number.
The prayer is allowed. Let this matter be listed. What is the matter?
Admission matter.
Let this matter be listed after
Till vacation.
3 weeks on a date to be fixed by
Criminal
registry.
For withdrawal. My lord, the court below has dismissed the CR case, my lord, which was in challenge.
Okay,
I have a copy of the order.
heard Mr. P.R. Sharma, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant criminal petition as the trial court has dismissed the
CR case 2251 of 2020.
PR case number 2251 of 2251 of
2021.
2021. Considering the submissions made by learned counsel, the prayer is allowed. This criminal petition is dismissed on withdrawal.
I'm deeply obliged.
Wait for your lordship.
Yes,
Lordship, I beg to mention for listing lordship on Monday, lordship,
next week on a date to be fixed by registry.
next week. Obliged, lordship.
Item 57.
May I plead your lordship, I may be allowed to withdraw this criminal division.
Heard Miss F. Hussain, learned counsel for the petitioner, and prays for allowing the petitioner to withdraw the instant criminal revision petition. The no liberty.
With liberty, your lordship. So we have to file the criminal petition, your lordship.
With liberty to file an appropriate application. The prayer is allowed with the liberty sought for.
Deeply obliged, your lordship.
Item 1.
May I plead your lordship, the service report was awaited.
Malad service completed, Malad. I just served upon the informant Malad.
Heard Miss M.K. Brown. Any amicus present in the court? Heard Miss M.K. Brown, learned legal aid counsel appearing for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, who submits that notice issued to respondent number 2 has been duly served. This no one has appeared for respondent number 2. Hence, this court intends to appoint an amicus curiae to defend the cause of the respondent number 2. Accordingly, Mr. Devarshi Kumar Bhattacharya, learned counsel whose name appears in the list of amicus curiae prepared by this registry of this court, is hereby appointed as amicus curiae for respondent number 2. The petitioner is directed to furnish a copy of bail application along with the annexures to the newly appointed amicus curiae within 2 days from the date of this order. The registry is directed to reflect the name of Mr. Devarshi Kumar Bhattacharya as amicus curiae for the respondent number 2 in this case. List this matter 22nd October.
Item 2.
Another matter out of same affair, listed before the honorable judge Sanjeev Kumar Sharma sir. I think 33 in court number 25 dollars.
When?
Today itself. Out of same affair. CD also receiving that cash first.
Okay.
Court number 25, I think 33 received. Out
Ah.
of same affair.
Heard Mr.
Okay.
A.K. Ahmed, learned counsel for the petitioner, who submits that a connected bail application arising out of same affair has been listed before a coordinate bench of this court, within bracket Honorable Mr. Justice S.K. Sharma. And in that case, case diary has been called for.
Already received also.
Registry to list this matter along with the,
BA number 2900.
along with
2900.
registry to verify the said fact and list this matter along with BA number
2900.
2900/2025
Yes, sir.
before appropriate bench.
Okay.
My lord, annexure one is FIR, my lord. This is related POSCO matter. My lord, the incident took place 8-9 months before. And after 8-9 months, the informant is given the FIR stating that his minor daughter, who was on the way to school, committed rape by the accused. And the main accused already been arrested, and he is a
Praise for allowing the petitioner to withdraw the instant bail application, anticipatory bail application. Prayer is allowed. This anticipatory bail application is dismissed on withdrawal.
68 from supplementary. May I please, Lordship? 482 application, Lordship. FIR is 15, Lordship. Petitioner is the registered owner of a truck, Lordship. Stolen from page 15, Bharnigular, Lordship.
Yes.
The allegation of the informant is that he hired a truck and loaded some tin sheet, and which was stolen. But petitioner is the registered owner of the truck. He is not with his truck, his driver misuse.
Yes. Some co-accused have been granted relief in this case. Let him appear. Heard Mr. B. Sutia, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner, namely Mantosh Kumar Shah, who is apprehending his arrest in connection with Sonapur PS case number 130/2025 under section 303 within bracket 2/317 within bracket 2/318 within bracket 4/61 within bracket 2 of BNS. The gist of accusation in this case is that on 16/8/2025, Pinku Kumar had lodged an affair before the officer in charge of Sonapur police station from an interior, alleging that he had had a 14-wheelers open body truck bearing registration number AS01JC 5643 on rent to carry 16-ton 500 kg of tin from Sonapur to Silchar. However, Sonapur to Silchar, stop. It is also stated in the affair that one driver, namely Utpal, was entrusted to drive the vehicle and take the consignment from Sonapur to Silchar. However, on 14/8/2025, when the driver was called, the driver was tried to contacted over phone. His mobile phone was found to be switched off, and no whereabouts of the vehicle was known. It is stated in the FIR that the informant therefore suspected that the goods might have been stolen. Stop. Learned counsel for the petitioner submits that petitioner is in no way involved in the offense alleged in the FIR. He is the registered owner of the vehicle, and the accusation has been made against the driver only. He, however, submits that police is searching for him. He also submits that the petitioner is ready to cooperate in the investigation. On the other hand, learned additional public prosecutor submits that some of the co-accused have been granted bail, granted protection by this court. Stop. Considering the fact that the petitioner has not been named in the FIR and the accusation leveled in the FIR is mainly against the driver of the vehicle, this court is of considered opinion that if the petitioner cooperates in the investigation, his custodial interrogation may not be necessary for fair completion of investigation of Sonapur PS case number 130/2025. Stop. In view of above, the above named petitioner is directed to appear before the investigating officer of the aforesaid case within 7 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with the aforesaid case, he shall be allowed to go on bail of ₹30,000 with one surety of like amount, subject to the satisfaction of the arresting authority. This anticipatory bail application, arresting authority with following conditions. This anticipatory bail application is accordingly disposed of.
Item 4. Highly obliged.
You are on this side.
For the state lodge.
Okay. What is the case?
Also, here we have challenged the order dated 28/5/25, whereby the interim Zimma of the vehicle was given to the accused person. It also kindly comes to page 18.
18.
18, Lordship, yes. This is the order, Lordship, that we are challenging. Page 19 is the relevant portion, Lordship.
Yes.
Page 19 is the relevant portion, Lordship. Last paragraph, Lordship, will kindly see. On consideration of the prayer of the petitioner, it is made clear that it is a charge-sheeted case and therefore the report of the OC Bodorpur was called for only to ascertain the authenticity of the ownership of the petitioner and not invited his expert opinion as to whether the seized vehicle can be given on Zimma by this court or not. Next page, Lordship, will kindly see. On the strength of the case law, Biswajit Day versus State of Assam, so and so, decided by the Honorable Supreme Court on 7/1/25, we have no barrier to give Zimma of even a customized vehicle for concealing any contraband and having evidentiary value. As for that, the IO OC should release the vehicle after preparing a video and still photographs of the vehicle and after obtaining all information.
Zimma
documents-
was given to the accused.
Yes.
Okay.
Now, Lordship, here the judgment that has been cited, Lordship, I have given a copy, Lordship. If Lordship kindly takes up the judgment, Lordship will kindly come to internal page 17, Lordship. Paragraph number 29.
Yes.
Paragraph number 29, broadly speaking, there are 4 scenarios. After all discussion, Lordship, the court has summed up these 4 scenarios, Lordship.
Yes.
Paragraph 29, though seizure of drugs, substance from conveyance.
What was seized?
Lordship, may Yaba tablets.
Okay,
And the owner himself was in the vehicle, Lordship.
okay.
So here, Lordship, paragraph 29, though seizure of drug substance from conveyance can take place in a number of situations, yet broadly speaking, there are 4 scenarios in which the drug or substance is seized from a conveyance. Firstly, where the owner of the vehicle is the person from whom the possession of contraband drug substance is recovered. Lordship, this is the scenario. Secondly, where the contraband is recovered from the possession of the agent of the owner, like driver or cleaner hired by the owner. We are not in this, Lordship. Not also in 3rd or 4th, but that apart, Lordship, I'm just reading. Thirdly, where the vehicle has been stolen by the accused and contraband is recovered from such stolen vehicle. Fourthly, where the contraband is seized, recovered from a 3rd party occupant with or without consideration of the vehicle without any allegation by the police that the contraband was stored and transported in the vehicle with the owner's knowledge and connivance. In Lordship, we are squarely covered in the first scenario and this.
Okay, but by now, the
No,
vehicle might have been
no,
released.
Lordship, interim Zimma was given. The Zimma has not yet been given to my information, Lordship. So I am praying, Lordship, notice may be issued and stay may be granted, Lordship.
Okay. Heard Mr. B. Sharma, learned counsel for the petitioner. This application under section 438/442 of BNSS has been filed by the state impugning the order dated 14/5/2025 passed by learned special judge FTC Shri Bhumi in special NDPS case number 94/2024 corresponding to Badarpur PS case number 234/24, whereby the interim Zimma of the seized vehicle was given to the respondent number 2, given to the respondent, who is also the owner of the seized vehicle as well as also the accused in the said case. Learned counsel for the petitioner has submitted that in the aforesaid special case, the contraband, that is Yaba tablets, were found concealed in secret chambers of the vehicle, and the owner of the seized vehicle was accused of possessing the said contraband. Learned counsel for the petitioner has submitted that the apex court in the case of Sanjay Karol, in the case of Bishwajit Day versus State of Assam, reported in 2025 3 SCC 241, has categorically observed that where the owner of the vehicle is the person from whose possession the contraband is recovered, the vehicle may not be released to such a person unless the reverse burden is discharged by the accused person. However, in the instant case, the the trial court, by passing the impugned judgment, have overlooked the said proposition of law and in violation of the guidelines of the apex court has given the interim Zimma of the said vehicle to the respondent. Stop. Issue notice to the respondent. No. Before that. Learned additional public prosecutor has submitted that though the impugned order was passed on 14/5/2025, but it has been informed that the respondent has not yet taken the Zimma of the said vehicle. Stop. Let the notice be issued to the respondent. The petitioner shall take steps for issuance of notice upon the respondent within 7 days from the date of this order. Fixed date at earlier. Date of this order returnable on 27th of October. In the meanwhile, considering the submissions made by learned counsel for the petitioner as discussed in foregoing paragraph, the operation of impugned order dated 14/5/2025 passed in special NDPS case number 94/2024 shall remain stayed till the next returnable date. List accordingly.
Just one clarification, Lordship, the interim Zimma was given by the order dated 14/5/25. Thereafter, Lordship, the IO of the case has filed an petition, Lordship, for reviewing and consideration of the Zimma petition that was rejected by the order dated 28/5.
Okay. Before, in the submissions of learned counsel for the petitioner, learned counsel for the petitioner further submits that though the interim Zimma was granted to the respondent initially by order dated 14/5/2025, the investigating officer had filed an application before the trial court for review of the said application, which was dismissed by the trial court on
28/5/25.
28/5/2025. উপরের যাবে, list accordingly.
It's also, Lordship, similar, but Lordship, here we are only praying for notice, Lordship.
Heard Mr. B. Sharma, learned counsel for the petitioner. This application under section 528 of BNSS has been filed by the state impugning the order dated 26/5/2025 passed by learned special judge Sri Bhumi in special NDPS case number 46/2024, by which the prayer for Zimma of the seized vehicle in the aforesaid case was allowed by the trial court in favor of the respondent. Stop. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondents within 7 days from the date of this order, returnable after 4 weeks. List accordingly.
Item 6.
May I please, Your Lordship? Here, Lordship, petitioner was convicted by the trial court, Lordship, and that was affirmed by the sessions courts also, Lordship. It's a NIA case, Lordship. Lordship, here the amount, check amount was double, Lordship. I am ready to pay, Lordship, but they are not accepting in installments. So I have to file this revision, Lordship. At this stage, Lordship may issue a notice, Lordship, let them come. I'll pay them, Lordship.
Okay. Heard Mr. M. Ahmed, learned counsel for the petitioner, This application under section 438/442 of BNSS has been filed by the petitioner, namely Niranjan Sharma, alias Niranjan Sharma, impugning the judgment dated 27/6/2025, passed by the Court of Learned Session Judge in Criminal Appeal number 23/2024, whereby it upheld the order of the upheld the judgment dated 13/2/2024, passed in CR case number 1950/2018 by the Court of Learned Judicial Magistrate First Class, Kamrup Metro. Stop. Issue notice to the respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 within 7 days from the date of this order, returnable after 4 weeks.
Lordship, there is 8 months sentence also in the order. Till that returnable day, if Lordship stays, Lordship.
No, whether any execution,
Yes, Lordship, we have started the execution strategy. After filing of this, I came to learn. Till that returnable date, no coercive action will be taken.
no, what is the ground?
My ground is that Lordship.
No, mere filing of revision will not entitle you. Let the other side come.
And
We
Lordship.
we'll give a fixed date.
Fixed date, sir.
Let them on 24th of October.
Here, initially, the petitioner was convicted under section 138 of Negotiable Instrument Act by the learned judicial magistrate First Class Kamrup Metro. Against that order, he filed one appeal before the learned session judge Lordship, and his appeal was partly allowed, Lordship, and against that, those 2 orders, he is before your Lordship. Now, Lordship, may kindly see page 20 of my appeal revision petition, Lordship. My first ground is that, Lordship, that the notice was not properly served, and before Lordship cause of action, Lordship, the present complaint was filed.
Page 28.
28, Lordship. This is the relevant portion of the appellate court's order, paragraph 19, Lordship, may kindly see.
Yes.
That in the present case, the demand notice was issued on 25/9/2018. And it was issued from Guwahati GPO. The notice was supposed to be delivered at Dodora PS District Kamrup. In the ordinary course of post, it ought not to have taken more than 1 week. So if we take 1 week, Lordship, it will go below the Lordship that 25/7, then 2/10/2018 is the date when notice was served. And from that date, Lordship, that 15 days time has to be given to the accused person for repayment. Only then cause of action will arise as per section 138, Lordship. Now, next time, Lordship may see, the complaint petition was filed on 11/10/2018. That before expiry of that 15 days period, Lordship.
Okay. Thereafter, what happened?
Thereafter, this was, Lordship, the learned trial court held that in 313, Lordship, he admitted that he received the notice. And I have the 313 copy, Lordship. It was asked to the accused that whether you received the copy. He said, yes, I received. But in 313, Lordship, the specific date was not put to him.
When 15 days would have,
It would be, Lordship, it is 17th day on, Lordship, that 11/10/2018. And Lordship, 15 days will be, Lordship, on
17/10/2018.
17/10 will be
Okay.
15.
Okay. Heard Mr. A.K. A. Ahmed, learned counsel for the petitioner, State is a party.
That is formal.
Also, Mr. K. Parashar, the additional public prosecutor. This application under section 438, read with section 442 of BNSS, has been filed by the petitioner, namely Muhammad Abdul Hamid, impugning the judgment and order dated 11/6/2024, filed, passed by learned Additional Session Judge number 2, Kamrup Metro, Guwahati, in criminal appeal number 106/2024, whereby it had partly allowed the appeal filed by the present petitioner by modifying the sentence imposed on the petitioner by the Court of Learned Judicial Magistrate First Class Kamrup Metro in CR case number 6127C/2018 on 6/8/2024. By the judgment passed by the appellate court, the sentence imposed on the petitioner on his conviction under section 138 of the Negotiable Instrument Act was modified from the sentence of imprisonment for 8 months to 6 months, and the fine amount was reduced from 8,16,000 to 6,50,000. Learned counsel for the petitioner has submitted that the trial court as well as the appellate court has overlooked the fact that the complaint was filed prematurely in violation of the provisions of section 138 within bracket C of the Negotiable Instrument Act. As he further submits that the appellate court, the Court of Learned Session, which court? Session Judge, Additional Session Judge number 2, has observed in the impugned order that the notice was posted when it was posted.
It was issued on
It was
25/9.
notice was issued from Guwahati GPO on 25/9/2018. And there is an observation made by the learned Additional Session Judge number 2 in the impugned judgment that in ordinary course the notice ought to have reached the appellant, the petitioner, within a period of 1 week. Learned counsel for the petitioner submits that even admitting what has been observed by the appellate court, the notice would have been received by the petitioner only on 17
On 2/10.
on 2/10/2018. He further submits that the complaint petition was filed in this case on 11/10/2018, which is before expiry of 15 days of the date of receipt of notice by the complainant. And therefore,
For repayment. Okay. After receipt of notice, that repayment period is 15 days.
before expiry of the payment time period granted by the statute for repayment of the check amount. So he therefore submits that the trial court as well as first appellate court have erred in convicting and confirming the conviction of the petitioner under section 138 of BNSS. Issue notice to the respondent number 2. Respondent number 1. The petitioner shall take steps for issuance of notice upon respondent number 1 by registered post with AD as well as by usual mode. He ordered to in main case as well as in IA common order. The, respondent number within 7 days from the date of this order, returnable on date fixed date, 23rd of October. However, in the meanwhile, considering the submissions made by learned counsel for the petitioner, as discussed in the foregoing paragraph, the operation of the impugn order, operation of sentence imposed on the petitioner by the impugn order shall remain stayed till next returnable date, list accordingly.
May please, madam. Also, if I have filed these revision petitions against the order 11/10/2025, my lord, page 33, my lord, impugn order. Against the CR case 2097, public 2019, my lord.
What is the order?
Order 33, page number 33, my lord.
What it says?
Order says, my lord, orders allow the PP file a petition before this court, my lord, which was objected by the defendant.
No, what was allowed by the impugn order?
My lord, that petition number, that petition is page number 25, my lord, annex 5. At the time of judgment, PP has filed a petition, my lord,
Seeking what? What?
seeking to compare the signature of the accused, to send the signature to the FSL. In this case, my lord, what happened, my lord? Brief of the case, my lord.
Now, what is the error in the order?
First of all, my lord, PP has no right to file the petition in the CR case, my lord.
Oh,
That is
this was a CR case.
yes, my lord. That is the case of CR case, my lord. Case
Okay.
was registered, complainant DK Das, my lord. Registered at Guwahati High Court Judicial.
No, you are unable to place your case
My lord.
properly.
So, a
Wha-
brief of the case, my lord.
Yes.
Defendant filed a case which was registered as a CR case before the CJFI. In this case, my lord, PP has appeared as a advocate of the respondent, my lord. My submission is respondents is a individual person. That is an individual case, CR case. CR case was registered under section 200 CRPC, my lord. So public prosecutor has no right to appear in this case and file any petition
public prosecutor has appeared as public prosecutor.
Yes. He appeared as a public prosecutor. He has filed his petition also in his capacity as a public prosecutor, madam. Additional public prosecutor.
Okay, the complaint was filed by the registrar judicial.
Yes, my lord. In his personal capacity, my lord, D.K. Das, my lord, not Guwahati High Court, my lord.
This needs to be examined. Yes.
Okay, we are not there. State is not there.
The complaint was filed as per the directions of this court.
Yes, my lord. That's all right. But complaint has filed in his own capacity.
Not,
in his
no,
own
no, not in his own capacity. It was as per direction of this court.
Yes, my lord.
At what stage this was allowed?
At the time of judgment, my lord.
Who prosecuted the case for the complainant?
Complainant is PP, my lord.
Then you did not raise objection.
Again and again, I am in my objection petition is clearly stated. I have filed against this petition also, I have filed an objection. Objection petition is there, my lord. In page number 6, my lord, my objection is there.
This need to be examined. Heard. Mr. A.R. Medhi, learned counsel for the petitioner. Also heard Mr. A.R. Medhi, learned counsel for the petitioner. This application under section 438 of 438/442 of BNSS has been filed by the petitioner Azizur Rahman, impugning the order dated 11/8/2025 passed by learned Chief Judicial Magistrate Kamrup Metro in CR case number 2097C/2019, whereby on an application filed by the learned public prosecutor on 4/10/2024, the prayer for sending the disputed signatures of the petitioner for examination or forensic examination by the Forensic Science Laboratory was allowed. Learned counsel for the petitioner has submitted that since the CR case number 2096-7C/2019 was a complaint case, the learned public prosecutor does not have any locus standi to appear in the same case. It appears I have considered the submissions made by learned counsel for both sides. Now, learned counsel for the petitioner. It appears that the complaint case was filed by one Mr. D.K. Das, Registrar Judicial of this court, erstwhile Registrar Judicial of this court, on the directions of this court passed in bail application number 1123/2019. The question as to who would be the prosecuting agency in such a case, such a complaint case, which was registered on the basis of directions of this court, is required to be looked into. Any amicus present? This, since it is apparent that from the order dated 28/5/2019, passed in bail application number 1123/2019, that the said complaint was not filed by Mr. D.K. Das in his personal capacity, but in pursuant to the directions of this court, passed in bail application number 1123/2019. Still, this court intends to go into the question raised by the petitioner, and therefore this court is not issuing any notice to the respondent at this stage. Instead, it intends to appoint one amicus curiae to assist this court in this case. Accordingly, Mr. Sarfaraz Nawaz, learned counsel whose name appears in the list of amicus curiae prepared by the registry, is appointed as an amicus curiae in this case. The petitioner is directed to furnish copy of revision petition along with annexures to the newly appointed amicus curiae within 2 days from the date of this order. The registry is directed to list this matter. The registry is directed to show the name of newly appointed, show the name of Mr. Sarfaraz Nawaz as amicus curiae in this case. List this matter on 23rd of October.
My lord, my interim PR may be considered.
No
in date,
interim.
my lord. Otherwise,
Whether it is maintainable or not, that question has been raised.
next date was fixed for 24, my lord. If the report has come, my lord, the matter will be impetuous.
Let it become infructuous.
The report will come, my lord, already report was called
You
for.
go through my orders. I have clearly indicated in the orders, we are examining the issue, but prima facie, I am of the view that this criminal revision petition is not maintainable, but still we are going into the issue. Yes.
May please, Lord. But here, my lord, we have challenged the order, my lord, page 65. Order dated 27/8/2025,
265, my lord.
What order?
This, my lord, what happened in this case, my lord? An FIR, date of incident, my lord, 28/2/2023. My mother was killed, my lord, and I have filed an FIR on 1/3/2023, 1st of March. Annexure 1, my lord. And in the said FIR, my lord, date of incident, my lord, 28/2/2023. It
No,
was
in which? The page, please repeat the page number 65.
65, my lord.
Yes.
Now, my lord, case, my lord, evidence has been, my lord, completed. SARS, my lord, everything has been completed. Defense also, my lord, closed. Case, my lord, argument also completed. Case fixed for judgment. During, my lord, judgment, this order has been passed, my lord, page 65.
What has been?
May I read, my lord?
Yes.
Accused so and
What
so.
is the gist? What it says, this order says?
By this order, my lord, date of incident has been corrected. And entire, my lord, evidence has been, my lord, the prosecution has been given, my lord. The chance to re-examine all witnesses, my lord.
Please read the order.
Accused so and so is are present. Today, the case is fixed for judgment. After perusal of the case report, it appears that on 23/6/2023, my learned predecessor framed formal charge against accused person under section 302(34) IPC. The charge was framed on 1st of March. The charge was framed on that on 1/3/2023 at 10:30 AM at village so and so within the jurisdiction of so and so police station. In furtherance of common intention of the accused persons, they committed murder by causing death of informant's mother so and so. On perusal of the case record, it appears that on 1/3/2023 at about 6:30 AM, in charge of so and so outpost received information from so and so, the Gaurav village, that on 28/2/2023 at about 11:30 PM, so and so killed her mother-in-law. The in charge of so and so outpost opened GDE number so and so dated 1/3/2023 and proceeded towards the place of occurrence. On 1/3/2023, the informant so and so lodged and written Ezehar, where he stated that on 1/3/2023 at about 10:30 PM, his wife so and so killed his mother. The prosecution examined the informant so and so as PW6, and he deposed that on 28/2/2023 at about 12 midnight, he received information that death of his mother at his workplace Sarkand. In cross-examination, he has stated that in the Azhar, he mentioned the date of occurrence as 1/3/2023. And on 8/3/2023, he filed an rectified FIR with a prayer to correct the date of occurrence as 28/2/2023. After perusal of the materials on record, it appears that the alleged incident of murder of so-and-so took place on 28/2/2023 at about 10:30 PM. It transpired that my learned predecessor, while filling up the charge form, the date and time of incident perhaps inadvertently mentioned as 1/3/2023 at about 10:30 AM instead of 28/2/2023 at about 10:30 PM. At the counsel of the parties, the learned advocate for the parties have fairly submitted that charge can be altered at any stage of trial. Section 239 BNSS empowered the court to alter the charge at any stage of the trial. To arrive at a just decision, it is necessary to mention the correct date, time, and place of incident to the accused person so that they can prepare proper defense for them. Our learned counsel for the parties on charge. From the case record, it appears that the accused persons on 28/2/2023 at about 10:30 PM at village so-and-so under so-and-so police station in the district of Borbeta, in furtherance of their common intention, alleged to commit murder of so-and-so, the mother of the informant. After perusal of the materials on record, the case diary, I find material against the accused persons
to prosecute them under section 30234 IPC. So formal search against the accused person is framed under section so and so. The search is framed and read over and explained to the accused persons to which they pleaded not guilty and claimed to be tried. On being asked, learned PP has submitted that the prosecution has already examined all the material witnesses, so prosecution will not examine any further witnesses or re-examine any of the witnesses already examined. Learned counsel appear for the accused, so-and-so has submitted that the defense will not cross-examine any of the witnesses. The learned defense counsels appearing for the accused, so-and-so, by filing a petition number so-and-so, has submitted that the defense intend to cross-examine PW 13, Dr. so-and-so, and also examine judicial magistrate so-and-so, who recorded the statement of witness Shaukat Ali Shikdar under section 164 CRPC. The prayer of the learned counsel so-and-so is allowed. Now, my lord, the judicial magistrate was not examined earlier. He was not, my lord, named as witness in the circuit also. Now, my lord, here, my lord, the charge has not been altered. Only date of, my lord, incident has been corrected.
That is the alteration of charge.
Oh.
That amounts to alteration of charge. And you have not objected to the alteration of charge before the trial court. The trial court has given you option of cross-examining. Where is the error?
I am the informant, my lord. I
Your-
am the informant in this case, my lord. Now, case has been fixed for judgment. Everything has been closed. No application
You are
filed.
the informant.
Lost it. No,
Why have you, you are
Now
PW?
fixed, my lord. Case 40.
So it is on basis of your deposition only the charges were altered. How you are prejudiced, how you are
Now,
suffering.
my lord, the re-examination of the witnesses, my lord, they can, my lord, completely sense the nature of the deposition.
Otherwise, on the question of date, your case will fail.
But in my deposition, my lord, everything has been, my lord, correctly mentioned. Yet, and they have crossed.
But unless charges are altered, apparently the date of commission of alleged offense is mentioned wrongly in the charge sheet. That has been rectified. There is no, yes, Mr.
Yes, my lord, PW6, PW6, no?
Yes,
In PW6 page 40, he, on oath, at that point of time, he also, his deposition also 28-2. That is the,
now, my lord, judicial magistrate, my lord, he was not listed witness in this case.
You can,
Defense also did not, my lord, give any evidence, my lord.
you can cross-examine.
he filed a rectified.
Court has power to examine
petition for rectification of
anyone.
the murder FIR.
This is, my lord, on the prayer of the accused, my lord.
So
not by-
otherwise also court has power to examine anyone.
And he was not asked by.
No, where is the error in the impugned
The
judgment?
entire character will be changed, my lord. And they will fill the lacuna, my lord, which they have not.
Moreover, this is an interlocutory, in the nature of interlocutory order. Revision does not lie.
Yes, sir.
Revision is not maintainable. Heard, yes,
Yes, then that also, my lord.
heard,
Well,
Mr.
on his application, his petition, it was altered, my lord, his
Heard,
deposition-
Mr.
deposition
R.
mentioned.
Ali, learned counsel for the petitioner. Also, Mr. K.K. Parashar, learned additional public prosecutor. This application under section 438/442 of BNSS has been filed by the petitioner, namely Jahirul Ali, impugning the order dated 27/8/2025 passed by learned session judge Borpeta in sessions case number 98/2023, whereby the charges framed against the accused persons of that case was altered by rectifying the date of commission of the alleged offense from 1/3/2023, which was mentioned in the previous memorandum of charges, to 28/2/2023. By the trial court. Learned counsel for the petitioner submits that the petitioner is the informant and has deposed as PW6 in the sessions case number 98/2023. He further submits that the petitioner has, while deposing as PW6, petitioner while deposing as PW6 has stated that the incident occurred on 28/2/2023 at about 12 at midnight. However, he had stated in the date of occurrence of offense to be 1/3/2023. He further submits that the petitioner had also deposed that later on he filed a rectified FIR with a prayer to correct the date of occurrence of offense to 2023. The learned counsel for the petitioner submits that the petitioner is aggrieved by the fact that after culmination of the trial, when the matter was fixed for delivery of judgment, the charges were altered, and the court has also summoned PW13 for cross-examination, as well as Judicial Magistrate N. Bhattacharya, who recorded the statement of the witness Shaukat Ali Sikdar under section 164 of CRPC as court witness. Learned counsel for the petitioner has submitted that alteration of charge at this stage would change the nature of the case, and by summoning the judicial magistrate whose name was not mentioned in the list of prosecution witnesses in the charge sheet, the undue advantage may be given to the accused persons. Stop. On the other hand, learned additional public prosecutor has raised a preliminary objection that a revision under 438/441 of the BNSS is not maintainable, in as much as the order which has been impugned in this case falls within the category of an interlocutory order. He also submits that it is the petitioner himself who, while deposing as PW6, stated before the court that the alleged incident had actually occurred on 28 to 2023 and not 1/3/2023. He therefore prays for dismissing the instant revision petition without issuing the notice. I have considered the submissions made by learned counsel for the petitioner, learned counsel for both the sides. Section 4 Section 239 of the BNSS empowers the court to alter charge at any stage of trial. And in this case, the date of alleged offense was rectified by the trial court in the memorandum of charges, as in the earlier memorandum of charge, the date was mentioned as 1/3/2023, which the present petitioner himself, while deposing as PW6, has contradicted and has stated the correct date to be 28/2/2023. It also appears that while altering the charge, the learned trial court had heard both the sides, and the petitioner heard both the sides, and no objection was raised by any of the parties. Further, this court is of considered opinion that as the charges were altered, the trial court rightly gave the opportunity to the defense side to further examine the witnesses which it desired to, and accordingly PW13 was summoned again for the purpose of cross-examination. As regards summoning the judicial magistrate N. Bhattacharya is concerned, the trial court does have the power to summon any person as witness at any stage of trial. Moreover, the objection raised by the public prosecutor regarding maintainability of this criminal revision petition, as the impugned order falls within the category of interlocutory order, may also not be overlooked. For aforesaid reasons, this revision petition is dismissed without issuing notice to the opposite party.
Item 10.
May I please? My lord, on last occasion on report was called for
The
from the IO.
IO, my lord,
What
a
report?
report, my lord, regarding Zimma, my lord,
Zimma.
Zimma was rejected. Report, still we have not received, we have sent the signal on 4/9, but we have incurred, my lord, report not received. Otherwise also, my lord, one thing is I'd like to point out, my lord, page 33, the last part of the order, page 30, last page, my lord.
Yes.
last page. The IO has also submitted that the actual owner of the seized items as well as the amount has not been verified yet. Also, the petitioner has not submitted any relevant document regarding the ownership of the seized items and amount. So, my lord, what is the wrong in the order, my lord? If it is not verified, owner is not known, no document produced, how can be Zimma can be given, my lord?
My lord, kindly for a moment. May I submit? Page number 12. my lord. List of stolen item, my lord. 1 diamond earrings, pair in gold, 1 diamond solitaire ring, 1 rough earring, 1 pair of gold, cash worth 1 lakh. My lord, kindly for a moment, page number 17, my lord. Particulars of seizure. Cash rupees 2,50,000 only.
Page number?
17 column 6, my lord. Particular of seizure. Cash rupees 2,50,000, my lord. Seized from me. Only 1 lakh rupees was stolen from the house of the informant, my lord.
You are accused.
My lord, I am one of the accused, my lord. I am a jeweler's by profession. I have submitted all those documents, my lord. Even I have submitted full mark, my lord. My lord, seizure list itself says that rupees 2,50,000 seized from you. What the documents will require, my lord?
And what was the accusation?
My lord, FIR is the page number,
FIR.
my lord, 11, my lord. Page number 11.
Okay. Then case diary would be required. How much cash was stolen? How
My
much
lord,
gold?
the
Suppose it is a
CD, my lord. CD.
CD would be required. Because it may be stolen property. In FIR, details are not given.
Well, that is all right, my lord. But my lord, where the complainant says, informant says that only 1 lakh rupees has been stolen from my house.
Where,
The
where,
investigation agency, my lord.
where?
My lord, page number 12, my lord. List of stolen items, my lord, page number 12. Cash worth 1 lakh, approx.
Yes.
Serial number 5, my lord, case worth 1 lakh, approx.
Okay, we'll call the case diary.
My lord, investigation agency seized 2,50,000. Is it stolen money, my lord?
Okay, heard. Mr. A. Parmani, learned counsel for the petitioner, also heard Mr. K. Parashar, learned additional public prosecutor, who submits that the report which was called for from the IO by order dated 3/9/2025 has not been received. He seeks some more time for production of the said report. The prayer is allowed. Also call for, considering the nature of relief sought for by the petitioner, perusal of the case diary would also be necessary. Hence call for the case diary. When?
22nd. 22nd of October. Or no, other
22nd October,
16 October.
16 October.
Ali, Ali.
Let this case be listed on 16th October.
Ali.
Item 11.
Yes.
This petition has been preferred under section 5. 8 of the PNS as well. Praying for quashing and recalling the order dated to 15/2/2025. First in PSC case number 598 of 2021. By this non-bailable warrant of arrest has been issued against me. And subsequently on committal, my lord, sessions case number has been registered as session case number 32 of 2025. My lord.
You are shown as an absconder
Absconder.
and 376 is there.
Yes, my lord.
Then Case diary
Trial
would,
is going on, my lord. PW one has been examined, my lord. On the next date, my lord, is fixed, my lord, 22/10/2005.
you have
Further evidence.
trial is going on means you once appeared,
No, my lord.
you have not at all,
Yes.
then trial is going on,
There are,
in
there are other accused also.
case has been split up.
That split up order has not been. Should not be appealed.
No, in your absence, how trial is going
Yes,
on?
my lord.
Can copy.
As orders, my lord.
Maybe well, the whole order. is
My,
not
my
before us.
humble submission before your lordship, my lord. The petitioner, my lord, he is ready to face the trial, my lord. On the next date, my lord, he will appear, my lord. In the meantime, my lord, he may be protected, my lord.
Protection.
As my lord, investigation has been completed, my lord, and trial is going on. And the next date is.
No, but you did not
10, my lord, for further evidence. PW. one has been
cooperated in the
examined.
investigation. You are shown as an absconder in the,
Absconder. Yes,
Protection in 528 minutes.
yes. That protection may be given, my lord. I will appear, my lord.
no protection. What happened to other co-accused persons?
This is the orders, my lord.
They are on bail.
Yes, my lord.
Yes. Which order?
After committing that order, sir.
What is your name?
My name is my lord Rabiul Hassan, my lord. My name is not there, my lord.
So your case was not even committed.
Yes, my lord.
Where is the FIR?
The FIR is at page, my lord, 15, my lord. Another copy. Page 15.
What is your name? Robiul.
Rabiul Hassan.
You are the main accused.
Kindly see the FIR, my lord. From perusal of the FIR, my lord, it seems that the case has been falsely incited. Victim's statement is also, my lord.
Where is the statement of the victim?
Have not-
Yes, Mr. Parashar.
Well, he is the main accused, my lord. Accused number one.
My submission is that, my lord, as the investigation has been completed, my lord, trial is going on, my lord.
You surrender before the,
That protection may be given.
No
my lord. He will
protection.
appear, my lord. On the next date, he will
Protection under
appear.
528 minutes.
He will appear on the next date, my lord. He will cooperate. with me.
oh, okay. We'll give protection to the extent that we
Yes.
will stay the execution of warrant till
Yes,
your
yes,
date.
madam. Till his appearance.
Heard Mr.
Yes, Islam.
S. Islam, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioner, namely Rabiul Hassan, who is impugning the order dated 15/2/2025, passed by learned SDJMS Borpeta in PRC case number 598/2021, arising out of Bagbhar PS case number 121/2021 under section 376D/379/506 of the Indian Penal Code. So, learned counsel for the petitioner has submitted that the petitioner has been shown as an absconder in the charge sheet and non-bailable warrant of arrest has been issued against him. in the said case. He further submits that the case of the co-accused have co-accused, namely Ghazibur Rahman and Mohibul Haq, has already been committed to the Court of Sessions by the committal court. He further submits that the petitioner is ready to cooperate in the trial and ready to appear before the committal court. However, he seeks some interim protection so that he may appear before the committal court. When is the next date fixed?
At 22/10.
Learned counsel for the petitioner further submits that 22/10 before which court?
In the case 29, my lord. Additional sessions, sir. Additional sessions.
How you will appear before additional session? Then you have to first appear before
Additional session court.
the committal court. Your case has not been,
Committed, my lord, yes.
whether your case was split up and then case of remaining accused.
This order has not been issued, my lord. But that is subdivisional judicial magistrate Borpeta.
Stop. Considering the submissions made by learned counsel for the petitioner, where is the committal order?
Committed order, my lord.
Which court issued warrant against you?
My lord, SBGM Borpeta, my lord. Subdivisional judicial magistrate Borpeta.
And where is the committal order?
Committed order I have not annexed, my lord.
So we don't have the facts where the case is pending. You find out, or we will call for the last Cali. No, continue. It appears that the learned counsel is unable to respond to the query posed by this court as to whether the case of the remaining two accused persons was split up and only their case was committed. Hence, and whether the case of present petitioner is still pending before the Court of Learned SDGM S. Borpeta in PRC case number 598/2021. Hence, let the scan copy of the records of PRC case number 598/2021 in respect of the present petitioner, namely Rabiul Hassan, be called for from the Court of Learned SDGMS Borpeta, the registry to issue requisition for the scanned copies. Let this case be listed again on 22nd October.
22nd.
October. You should have placed all the.
Prior to 22, my lord. It's because my lord, 22 is my fixed, my lord, in the court of London session, that's my lord.
But in your case has not been committed.
Yes,
You are unable to say the status of
22. Obligation.
Item 12.
No, please, Your Lordship.
This is the 528 application, my lord. For quashing of the FIR filed against the petitioner, my lord, by the informant. My lord, this is absolutely a frivolous, my lord, FIR that has been filed by the informant. Fact remains, my lord, that the petitioner as well as the informant, my lord,
where is the affair?
FIR, your lordship will find at page 37.
37.
My lord, the petitioner and the informant admittedly, my lord, they were in relationship. My lord, your lordship,
Whether charge sheet has been laid?
not yet, my lord. The investigation is on. My lord, the petitioner has been placed under suspension. Now, my lord, he is also not getting.
Charge sheet has not been submitted.
No, my lord.
Then what is annexure 4?
Annexure 4 is the FIR filed by me, my lord. What has happened? My lord, your lordship,
No, no.
may I
Before that,
the facts, my lord, first.
yes, but before that, where is the impugned affair?
Yes. Impugned FIR before that, my lord, let
No,
me say something.
let me go through the impugned
FIR, my lord, it is at page 37.
27.
37, my lord, annexure 6, 37. Vernacular, your lordship will find page 39.
Yes, now you say, what is your case?
Yes. My lord, this FIR was filed, my lord, absolutely, my lord, with malafide the intention, my lord, with vengeful motive, my lord, to harass the, my lord, petitioner. My lord, there was a love affair in between the informant and the, my lord, the petitioner. My lord, they had for about 3 years, my lord, they were in relationship and everything was fine, my lord. There was no dispute or differences in between the informant and the petitioner, my lord. The problem started, my lord, when the,
You are on bail in this case.
my lord, I am on bail.
You are on bail. We'll call for the case diary.
Yes.
Heard. Mr. P.K. Sen, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 528 of BNSS 2023 has been filed by the petitioner, namely Dr. Selix Alam, who praying for quashing of the FIR lodged by the respondent number 2, on the basis of which Margarita PS case number 22/2025 under section 127 within bracket 2, 68 within bracket D, 351 within bracket 2 of BNSS was registered. Issue notice to the respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 by registered post with AD as well as by usual mode, returnable on 24th October. Let also the case diary of Margarita PS case number 22/25 be called for, list accordingly.
Till returnable date, my lord.
What? What do you want?
That the further proceeding of
No.
investigation. May kindly
No,
dictate.
no. Next item.
I am deeply obliged.
13.
Mr. Lordship, I am praying for issuance of notice, Lordship, against the order dated
Zimma order.
No, Lordship, here, Lordship, I am challenging the order of bail granted. Lordship.
Bail. Cancellation of bail.
Cancellation of bail. Notice at this stage.
Heard Mr. B. Sharma, learned additional public prosecutor. This application under section. Under what provision you have filed?
Yes, Lordship, under 528.
Under section 528 of
BNS.
BNSS has been filed by the petitioner impugning the order dated 8/9/2025 passed by learned special judge in charge Karbi Anglong in connection with Howrah Ghat PS case number 20/2025, whereby the respondent was allowed to go on bail by the said court. Issue notice to the, it is pending investigation.
Yes.
Issue notice to the respondent and call for the case diary. The petitioner shall take steps for issuance of notice upon the respondent by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable on 23rd October.
14.
Maybe.
Yes.
Here, charges have been framed, my lord, under 302. If I may take your lordship to the FIR first, my lord, at page 20. What has happened, my lord, the petitioner, my lord, before your lordship is a pharmacist. And
You are impugning what? Framing of charges.
framing of charge, my lord. Charge has been framed under 302 IPC, my lord.
We'll call for the scan copy of the case diary.
The FIR, my lord. The FIR says, my lord.
No, suppose you have a case. We have to peruse the case diary. Your case is that charges have been wrongly framed.
Fine.
It ought not to have been framed.
And that is one room of argument, my lord. The other, why I'm assailing the order of the charge, my lord, on the basis of that he have, without going into the materials, those materials were not before the learned judge, my lord. He have only taken the consideration of the charge sheet, which the learned judge could not have, my lord.
Taken the consideration of
The amendments made in the charge sheet, not on the basis of some materials before, because the charges have to be framed, my lord, on the basis of the materials which are produced by the prosecution.
yes, for that case diary would be required. Heard Mr. P.K. Munir, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 528 of BNSF has been filed by the petitioner Juran Ali Ahmed, impugning the order dated
Order dated 19/6/2025.
passed by learned Session Judge Baksa Mushalpur in Sessions case number 53/2025, whereby charge under section 302 of the Indian Penal Code has been framed against the petitioner. The issue notice, the petitioner shall take steps for issuance of notice upon respondent number 2 by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable on 24th of October. Let also the scanned copy of the case diary of which is Govardhan Police Station case number 89/2024, as well as the scanned copy of the records of sessions case number. What is the sessions case number?
53 of 2025.
53 of 2025. We called for from the trial court. Registry to take steps for requisitioning the scan copy, list accordingly.
Next date is on 13/11. My lord has fixed on of October.
October.
If I may, pray, my lord, that dusty service may be allowed for to respond.
Oh, this is criminal case.
My lord is fixed it on
20.
24/10. I'm deeply obliged.
Item number?
The plea,
Yeah, yes.
my lord. This is a Quashing petition, my lord, but under section 528 of the NSF for quashing the CR case and along with the Cognizance order was the on the trial court against the petitioner, my lord. Well, petitioner here are 4 numbers of petitioners, all the petitioners are women, and particularly petition number 3 and 4 are in the portfolio of some women organization, my lord. The complaint petition, lordship may kindly find the complaint petition in page number 59, the vernacular form of the complaint petition, my lord. Cognizance has been taken under section 500 IPC, my lord, for defamation. My lord.
Where is the complaint petition?
The petition, my lord, page 49. But you will find the vernacular form of the complaint petition, my lord. Page 49. My lord. Lengthy complaint petition, my lord.
Now, what is your ground?
My lord, my ground of questioning the petition only barred by limitation, my lord. Under section 468 of CRPC, my lord. The alleged defamatory statement to have been made in the year 2018, my lord. And the CR case has been filed against the petitioner only on in the year 2024, my lord. That is on 29 to 2024. It is specially barred by limitation under section 468 of CRPC. And next, lordship may kindly see the cases of the opposite party. There is a complaint in the CR case. Examined under section 200 CRPC, my lord. Case starts from 59, my lord. He categorically stated,
What is the corresponding provision to 468
my lord,
in BNSS?
BNSS 514, my lord. The earlier 468 subsection 2 clause C CRPC. The punishment of 500 IPC is maximum 2 years. In that case, 3 years is a limitation in filing a complaint case.
And 195A
My lord,
under section 1. What is 195A? Cognizance has been taken under section 500
500 max, yes.
and 195A. Or only under section 500?
Only 500, my lord. Lordship may kindly seek the cognizance order passed by the land and magistrate, my lord. Lordship will find. Page 70, my lord. Section 500.
Where is the statement that
My lord,
the defamatory statement was made in the year 2018?
lordship will find. 119. It's a memorandum.
119. Is 119 my lord. Along with more than 10 persons, along with there is one petitioner only named.
No, what is the accusation?
My lord,
In the FIR, what is the allegation?
it was not an FIR, but it was a memorandum, my lord, that has been made by Protection Officer Dhanaji. Allegation is that there are a lot of cases. As of now, there is also a pending case against the opposite party under Section 76, my lord. Since 2010, my lord.
No, in the complaint petition, where is the allegation?
My lord.
That this
Relevant part,
memorandum
my lord.
has defamed you.
My lord. My lord, Lordship will find the relevant portions of the complete petition 52 page, my lord. Page number 52.
Yes,
May I read, my lord?
yes.
মানে দুখৰ বিষয় এই যে অধীনে পৰিচালনা কৰে এই অনুষ্ঠানৰ উন্নতি দীক্ষান্বিত হৈ এই অনুষ্ঠান বন্ধ কৰিবৰ বাবে কুস্বাৰ্থ জড়িত হৈ অধীনৰ ওপৰত এই অনুষ্ঠানৰ ওচৰত বসবাস কৰা শ্ৰী গিৰীশ শইকীয়া, শ্ৰীমতী বাগী গগৈ, শ্ৰীমতী মণি কোঁৱৰ শইকীয়াৰ লগতে নীলিমা লাহন আৰু ৰঞ্জনা বৰুৱা নামৰ মহিলা দুগৰাকীয়ে মহিলা সমিতিৰ নাম লৈ অধীনৰ অনুষ্ঠানৰ দ্বাৰা পৰিচালিত গৃহত থকা শ্ৰীমতী অনিতা গড় নামৰ ছোৱালীজনীক ব্যৱহাৰ কৰি তেওঁক উচ্চতাই ফুচুলাই প্ৰৰোচনা কৰাৰ লগতে ভয় ভাবুকি দি অধীনৰ অনুষ্ঠানটিক বদনাম আৰু কালিমাহানি বন্ধ কৰা কুঅভিপ্ৰায়েৰে অধীনৰ ওপৰত আৰু অনুষ্ঠানটিৰ কৰ্মকৰ্তা শ্যামল গগৈ আৰু শিশুগত আশ্ৰয় লৈ থকা শিশু দীপাংকৰ চুতীয়া নামৰ সখীটিৰ ওপৰত যৌন উৎপীড়নৰ এক মিছা ও মনেৰজা গোচৰ তৰি যোৱা ইংৰাজী 8/1/2018 তাৰিখে চিলাপথাৰ আৰক্ষী থানাত এখন এজাহাৰ দাখিল কৰে। চিলাপথাৰ আৰক্ষী থানা উক্ত এজাহাৰ ভিত্তিত চিলাপথাৰ থানা 6 ইঞ্চি গোচৰৰ পক্ষৰ অধীনত পঞ্জীয়ন কৰি শ্যামল গগৈ গ্ৰেপ্তাৰ কৰি জিলা জেলত প্ৰেৰণ কৰে আৰু দীপাংকৰ চুতীয়াক উক্ত গোচৰৰ পৰা ৰেহাই দি পুনৰ আশ্ৰমত থাকিব দিয়ে। উক্ত গোচৰ অধীন মহামান্য জিলা ছেছন আদালতৰ জামিনত মুক্তি লাভ কৰি শ্যামল গগৈ এক দীঘলীয়া সময় ধৰি জেল হাজতত থাকিবলগীয়া হয়। এই গোচৰ এজাহাৰ অধীনকে ধৰি অন্য দুজনৰ ওপৰত ঘটনা সম্পৰ্কত মিছা কৰি মনেৰজাৰ তথ্য বৰ্ণনা কৰে এনেদৰে FIR was not lodged by the petitioner.
Okay, where is the cognizance taking order?
My lord.
Order taking of the cognizance
Yes, my lord. In this case, CR case, my lord.
in CR case, which
Yeah.
you are impugning.
Yes, my lord. Page 70, my lord. Only section 500. Against all the petitioners under section 500 IPC, my lord. And this order of cognizance is also barred by, this also suffering from illegalities, my lord.
What illegality?
My lord, as per section 223 of BNSS, subsection 1, before taking cognizance, pre-cognizance taking notice has to be issued to the petitioner. To the
Yes,
accused person.
yes.
Has to be heard.
That
before
was
taking
not
cognizance.
heard. Yeah,
My lord,
that was not followed.
not followed. My lord.
Okay.
It apparently, my lord.
Okay, heard. Mr. S. Gogoi, learned counsel for the state is a party.
My lord, only one part. No, but it is CR case only, my lord. Private complaint, my lord.
Heard Mr. S. Gogoi, learned counsel for the petitioner. This application under section 528 of BNSS has been filed by the petitioners, namely 1. Bohage Gogoi, number 2. Moni Kour Soikia, number 3. Nilima Lahon, number 4. Ranjita Borwa, impugning the order dated impugning the
2025, my lord.
order dated
15 February 2025, my lord.
15th February 2025, passed in CR case number 14/2024 by the Court of Learned Judicial Magistrate First Class Themaji, whereby cognizance of offense under section 500 of IPC was taken against the present petitioner. Learned counsel for the petitioner has submitted that in the complaint filed by the respondent, it has been alleged that by submitting a false memorandum before the Child Protection Officer, Dhemaji District, on 2018, some defamatory accusations were made against the respondent. Learned counsel for the petitioner has submitted that even if it is assumed that the averment made by the respondent in the complaint are true, still the said complaint is barred by limitation, as the maximum punishment prescribed for an offense under section 500 IPC may extend
2 years back.
up to imprisonment for 2 years, whereas the defamatory, whereas the memorandum which was stated to be defamatory in nature was filed before Child Protection Officer in the year 2018. He submits that section 514 within bracket 1 within bracket C would say bar to take cognizance of an offense for which taking cognizance after beyond the period of 3 years for an offense punishable with imprisonment for a term exceeding for a term not exceeding 3 years. Learned counsel for the petitioner has also submitted that in this case, while taking cognizance against the petitioners by way of by passing the impugn order, the learned trial court has not followed the mandate of proviso to section 223 within bracket 1 of the BNSS, as the said provision puts a bar in taking cognizance of an offense without giving the accused persons an opportunity of being heard, which was not given in this case. Stop. Issue notice to the petitioner, issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by registered post with AD, as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. Stop. In the meanwhile, considering the submissions made by learned counsel for the petitioner, as discussed in the foregoing paragraphs, further proceedings of CR case number 14/2024 pending before the Court of Learned Judicial Magistrate First Class Dhemaji shall remain stayed until next returnable date. List according.
16. My pleasure. The implication for quashing the AWA, which is issued against the petitioner, my lord, My lord, can you see the page number 37, my lord? That is the impugned order, my lord. Page number 37.
NBWA.
Yes, ma'am. Page number 37.
Yes.
My name is Noor Islam Sheikh, my lord. My lord, I am ready to appear before the trial court, my lord. My lord, if without protection, my lord, I appear, my lord, I maybe put behind the bar, my lord. Since my lord, entity issued against me, my lord.
Whether you received summons,
No, my lord, I did not receive any summon, my lord. in the court.
page number,
37.
37.
what is your name? Rahul.
No, my lord, Noor Islam Sheikh.
Here it is, no issue.
But you received bailable warrant of arrest.
I was not available at home, my lord. My lord was, my lord, outside the district, my lord. That is Guwahati, my lord. I could not receive the sum, my lord.
Let him appear. Heard Mr. S. Rahman, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor. This application under section 528 of BNSS 2023 has been filed by the petitioner, Noor Islam Sheikh, being aggrieved with the order dated 23/6/2025 passed by learned additional session judge,
My lord, special
additional
judge.
special judge
Sorry,
Dhubri,
my lord, special judge.
passed by learned special judge
Additional.
Dhubri in special case number 68/2025, whereby non-bailable warrant of arrest was issued against the petitioner. Learned counsel for the petitioner submits that the petitioner has never received any summons from the trial court and he is ready to cooperate in the trial. The next date of
My
the
lord, 23/9.
next date is of the said case is fixed on 23/9/2025. Stop. Considering the fact that the petitioner is ready to appear before the trial court on the next date fixed, that is 23/9/2025 in special case number 68/2025, this criminal petition is disposed of with a direction to the petitioner to appear before the trial court on 23/9/2025 in special case number 68/2025. To facilitate his appearance before the said court, the operation of non-bailable warrant of arrest issued against him by the trial court shall remain stayed till that date. This criminal petition is accordingly disposed of.
Bless.
17.
Yeah, please, your lordship. What if there is a quashing petition, lordship, for quashing of a criminal proceeding, lordship? In this case, lordship, charge has been framed under section 13(1) of the Assam Cattle Preservation Act, lordship. Absolutely, lordship, the order, lordship is. has been
Charge has been
authenticated by-
framed.
Yes, section 13, in order to make out the case under section 13, there has to be a violation under section 4, 5, 6, 7, 8, and 8. There is not a single ingredients of section 4, 5, 6, 7, and 8 in the instant case.
Okay.
And moreover, the FIR is lost by a police personnel, a inspector in the vigilance department. He is a sub-inspector in the Directorate of Vigilance and Anti-Corruption. And section 11 of the Act, Cattle Preservation Act, also says that it is to be inquired or investigated by an officer within the local limits of jurisdiction of such person. So my respectful submission is that the information is not within the local limits of the jurisdiction.
which provision you are,
Section 11 of the Assam Cattle Preservation
what
Act.
it says?
It says that for the purpose of enforcing the provisions of this act, a police officer not below the rank of sub-inspector or a registered veterinary officer or any person authorized in this behalf by the state government shall have the power to enter and inspect any premises within the local limits of jurisdiction of such person, where he has reason to believe that an offence under this act has been or is likely to be
That
committed.
is power to enter and inspect only.
Lordship. Now, the
Oh,
first
well.
line of the FIR itself says that inquiry was conducted by this particular officer. If Lordship comes to the first sentence of the FIR, that Lordship will find at page 24.
No, this provision, section 11 does not. You are saying that it bars inquiry also.
No, it has to be within the local limits of the officer, either inquiring or investigating the offence, Lordship. And in this case, Lordship, the FIR is lodged by an officer who is from the Directorate of Vigilance and Anti-Corruption. Directorate of Vigilance and Anti-Corruption has been set up in the year 1983 to inquire and investigate into offences of pertaining to corruption by public servants.
But 11 does not pertains to inquiry investigation. It pertains to power of search and seizure.
Yes, search was
It
done
is
by this
search and
person.
seizure is different.
This person conducted the preliminary inquiry in this case. As per the FIR, it is also revealed that he
Okay,
entered the premises of
we'll examine.
that. And as far as section 13(1) is concerned, for section 13(1) to attract,
The ingredients of,
there has to be a violation under section 4, 5, 6, 7, and 8. Lordship, this is section 4. What does
no,
section
okay, to appreciate your submission, case diary would be required,
30 charge sheeted, Lordship?
but still case diary would be required.
Already charge sheeted and charge has been framed under section 13(1).
Okay, heard Mr. A. Ganguly, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public
Lordship,
prosecutor.
another submission, Lordship.
Yes,
The officer who has filed this FIR, he is speaking about the fact that there is some misappropriation with regard to the cows that went missing, some of the cows, but all the permission and permits have been issued by the veterinary department. And section page 30, the utilization certificate is also issued by the department. So where is the case under section 13, Lordship? I have satisfied.
this application under section 528 of BNSS has been filed by the petitioners, namely Jawan Basumatari and their Shahad Basumatari, praying for quashing of the criminal proceedings of sessions case number T2/89/2024 under section 13 within bracket 1 of the Assam Cattle Preservation Act 2021. Stop. Charges are framed only under 13(1).
Yes, only under 13(1).
13(1). Stop. The petitioners are also impugning the order dated 24/3/2025 passed in the said case, whereby charges under section 13 within bracket 1 of the Assam Cattle Preservation Act 2021 has been framed against the present petitioners. Since the learned additional public prosecutor has appeared for the respondents, no formal notice need to be issued to the respondents. However, for appreciating the contentions raised by the learned counsel for the petitioner, scanned copy of the case diary, perusal of the scanned copy of the case diary would be necessary. Hence, call for the scanned copy of the trial court records as well as scanned copy of the case diary of Kokrajhar PS case number 525/2022 from the trial court. Registry to issue requisition. Registry to take steps for requisitioning the aforesaid scan copy. Let this case be listed on 23rd October.
He then lordship stay on the proceeding lordship. Otherwise,
No,
case is not at all maintainable.
we will examine. If you succeed, we will quash the,
Either from the point of view of FIR or either.
what is the next date?
15/11 lordship.
So what do you want to stay?
Stay
I am fixing a date before 15/11.
it be 4th week of October then.
4th week. 29th of.
20.
Item 18.
Made prison lordship. My lord, the petitioner before your lordship, he is a journalist, my lord. And he is operating a new channel through the, my lord, YouTube. And my lord, the alleged offending article is at page number 51, my lord, the FIR.
51.
Yes. Respected sir, I, Sri Alok Borua, 23 years of age, so respectfully submit this complaint against Officer Sharma, a television journalist, for committing offense under section 152, 196, 197 of the Bharatiya Nyaya Samhita. That Officer Sharma, the accused, having vested interest with malignant intent to disrepute and malign the duly elected government of Assam and Union of India, published and circulated an article through an online platform which contains statement ridiculing and denigrating the duly elected government of Assam and India, Union of India, stating that government survives only on Hindu-Muslim polarization, thereby provoking communal sentiments, accusing the Chief Minister of Assam of communal politics, and promoting enmity between different groups on the ground of religion, prejudicial to the maintenance of harmony, mocking and ridiculing the principle of Ram Rajya, etc. The link of the said article circulated on YouTube is given in so and so. The true typed transcript of the complete recording of the said article published circulated on YouTube in Hindi and English, along with the complete recording, is being submitted herewith in a pen drive as Annexure 1. That perusal of the article published circulated by Officer Sharma, the accused, clearly reveals that it contains statement ridiculing and denigrating the duly elected government of Assam and Union of India, thereby endangering sovereignty, unity and integrity of India. Further, the accused mocked and ridiculed the principle of Ram Rajya and openly accused the Chief Minister of communal politics, thereby attempting to create distrust and hatred against the government established by law and promoting enmity between different groups on the ground of religion, prejudicial to the maintenance of harmony. The transcript of the relevant extract from this said article published circulated by accused Officer Sharma reproduced herein under for your kind perusal. But the question arises, how does Himanta Biswa Sharma get away with all this so brazenly? The answer is simple. His politics is based solely on Hindu-Muslim polarization. By spreading hate, people's attention is diverted from such serious issues. Friends, now you understand why Himanta Biswa Sharma constantly spews venom, constantly raises Hindu-Muslim issues. Remember in Jharkhand, he said, if you want to do politics, you must say Jai Sri Ram. This is happening in today's so-called Ram Rajya. Without any basis whatsoever, the accused has alleged that government survives only on Hindu-Muslim polarization and repeatedly provoke communal sentiment, which has clear potential to disturb public peace, inflame passion, and create disaffection towards the state and promoting enmity between different groups on the ground of religion, prejudicial to the maintenance of harmony. The transcript of the relevant extract from this said article published circulated by the accused Officer Sharma are reproduced herein under for your kind perusal. But the question arises, how does Himanta Biswa Sharma get away with all this so brazenly? Answer is simple. His politics is based solely on, well, it is a repetition.
that para 5, that the article published circulated by accused officer Sharma is not mere criticism but amounts to an attempt to excite disaffection, provoke public disorder, and endanger the unity and integrity of India by portraying the state as a corrupt, communal, and illegitimate, thereby committing an offense under so and so. That the article published circulated by accused officer Sharma amounts to promoting enmity between different groups on the ground of religion, prejudicial to the maintenance harmony by saying that Himanta Biswa Sharma constantly spews venom, constantly raises Hindu-Muslim issues, committed the offense, etc. My lord, this particular affair was put to challenge before the Honorable Supreme Court, my lord. That lordships will get the order at page 54. Upon hearing the counsel, the court made the following order: issue notice only with respect to challenge to virus of section 152 of Bharatiya Nyaya Samhita is 23 is concerned. Tag with petition also. Insofar as challenge to FR is concerned, we are not inclined to interfere with the same. However, we grant interim protection to the petitioner for a period of 4 weeks so as to enable him to approach the High Court. What had happened, my lord? Virus of section 152, so far as that aspect is concerned, my lord, Apex Court was of the view that Apex Court will examine that aspect. However, my lord, challenge to the FIR was relegated to your lordships by giving an interim relief for a period of 4 weeks. That is how we have filed before your lordships.
So you are now under interim protection.
Yes. My lord,
When this 4
until
weeks?
today. My lord, my humble submission is very simple. In democracy, dissent is something which one has to accept. End of the day, my lord, if this is how every, what to call it, my lord, criticism of the government is to be construed as a sedition, my lord, it will be a very black day for democracy, my lord. End of the day, you must have a strong shock absorber, because you are ruling, you must know how to absorb it. Now, yes, my lord, what is the wrong in it, my lord? Day in and out, we often see newspaper, often see
The
TV.
case has been registered under section 150.
152, 196, 197.
What is 152?
152 sedition, my lord.
Sedition 196
My lord, promoting enmity.
and 197.
Assertion prejudicial to national unity, integrity.
Okay.
My lord, which assertion, well, all that the petitioner says is, petitioner was referring to the Honorable Chief Minister saying something in Jharkhand. Very naturally, whatever he said, that has been said. Now, that is a thin line of distinction between criticism and, my lord, a criminal offense. Which is the dividing line? Whereas one, my lord, where one draws the line? End of the day, my lord, if your lordship should kindly come to the Supreme Court judgment in, my lord, Vinod Dua's case, I'll just refer to 2 paragraphs, my lord, more or less similar situation. And lordship note, in Kedarnath's case, Supreme Court drew a distinction between.
We will call for the case diary, examine the issue.
And my lord, will till then, lordship will kindly extend this interim order
Yes.
till then, my lord.
Yes. You have anything to say?
My lord, regarding the interim order, my lord, Honorable Supreme Court also, my lord, directed to approach the High Court. And regarding that, my lord,
Investigation is going on.
Yes, sir.
Oh.
regarding my lord, bail, my lord, they can approach the, my lord, appropriate from, my lord, in appropriate application, my lord.
No, lordship, kindly examine the matter. All that I'm saying is Supreme Court has given us protection to approach the Honorable High Court. So we are before lordship will kindly have a look at the case, that till then will lordship protect us. As I was submitting, there is a distinction between a government established by law and the person who are managing the affairs of the state. When we criticize the person who are in charge of the affairs of the state, we do not criticize the government established by due process of law. As a fine line of distinction, which was drawn by the Supreme Court in Kedarnath Singh's case, which has been reiterated in Vinod Dua's case, Mila.
Okay.
Regarding the stay, I would like to point out one Supreme Court judgment, 2021 Supreme SCC 11444. Siddhartha Mukesh Pandari versus State of Gujarat and another. Here, I am reading only one paragraph. Paragraph 5, Roman 16. The aforesaid parameters would be applicable and or the aforesaid aspects are required to be considered by the High Court while passing the interim order in quashing petition in exercise power under Section 482 CRPC and or under Article 26 of the Constitution of India. However, an interim order of stay of the investigation during the pendency of the quashing
No,
petition.
we are not staying investigation.
Otherwise also, regarding.
No, what Supreme Court meant when it said that interim protection to petitioner, what it meant,
No coercive action till then, my lord.
what it meant. No court.
Coercive measures, my lord, in one of the judgments, Supreme Court
Whether
has
you
said
have
you
to-
cannot file a charge sheet. You can do investigation and all, but you cannot file charge sheet. Perhaps you cannot arrest him. In one of the judgments, Supreme Court has taken that view, my lord.
But Apex Court has also observed that the court, while granting such relief, has to clarify what it means.
In fact, my lord, I am holding 2-3 orders where Honorable Supreme Court has said in a similar situation, my lord, no coercive measure till then.
But in this case, that language has not been used.
No, but I am
Grant
holding 2 other orders.
Protection to
Till such
protection
time
from
I
arrest.
approach courtships, they will not arrest me or my lord, they will not. End of the day, my lord, in one of the case, Supreme Court has clearly said that when it says no coercive measure, meaning no charge sheet. That judgment I am holding it, my lord.
Without leave of the court.
Yes.
But one query. But suppose you need protection from arrest, then should you
No, my lord,
pray for?
here is a case, certainly I am seeking protection from the arrest, but my humble submission is, my lord, what is the offense I have committed? Criticizing the government, does it necessarily lead to, my lord, invoking the provisions under 152, 196 and 197? All that I am saying is, my lord, what the Chief Minister has said, only that much I have said. My lord, everybody has seen in the public glare what he uttered in Jharkhand, my lord. Everybody has seen it. So, my lord, he is reported that only. He said, is it not polarization of Hindu-Muslim? That's what, my lord. If that much of liberty under Article 19(1)(a) we do not have.
I am not on that.
Yes.
I am on, suppose you are seeking some interim relief.
Yes.
You have to be clear what kind of interim.
Seeking is, my lord. At this stage, they will not proceed. Further, lordships will examine the matter. Thereafter, let them do. Depending on lordship's decision, my lord, they will proceed. Supreme Court has given that, and Supreme Court has as prima facie satisfied with the virus of the provision itself. End of the day, my lord, 192, 124A, 124A, my lord.
152 is,
Now 124A, IPC 1, my lord. Now it is 152.
152 is under examination
Yes.
by the Apex Court.
Yes. In this case.
In this case.
only.
Okay.
The reason is very simple, my lord. On one hand, we are saying we have a right under Article 19(1)(a). On the contrary,
No,
we criticize.
my query remains.
Oh, I'm sorry.
What relief you are seeking?
Today,
Supreme Court has not
spelled out.
stalled the investigation.
No.
Only protection to you.
Yes, for no coercive
No.
measure, perhaps.
Protection to you.
Yes.
Now, what protection you are seeking from me?
I
This
should not
court.
be interested, my lord.
But for that, a different provision.
Not necessarily, my lord. That protection lordships can also give here also, my lord. End of the day, lordships power under 482 that remains. Merely because, my lord, Supreme Court has also said in Purnami Oil Mills case, if exercise of power is traceable to a legitimate source, merely because that provision is not mentioned, that does not mean that court cannot exercise that power. My lord, I am a journalist. I have come out with some publications. Now, in respect of those, my
No,
lord,
you approach the court, appropriate court, seeking protection from arrest.
These lordships can observe that till then no coercive measure, my lord, that will do for the present.
You are
Yes.
willing to approach.
Yes.
My lord, regarding that, my lord, just I would like to point out that very judgment, my lord, just one line. Normally, when the investigation in progress and the facts are
Wait,
heavy and entire evidence and material is not before the court, the High Court should not restrain itself from passing the interim order of not to arrest or no coercive steps to be adopted. And the accused should be relegated to apply for anticipatory bail under section 438 of the CRPC before the competent court. That observation is there, my lord. So,
Okay.
my lord, they may seek appropriate application.
Heard.
my lord.
Sir, for the sake of argument, my lord, supposing today I say, no, I'm seeking further stay of the investigation. That also I can say. But whether lordship will grant it or not, that's a different aspect. End of the day, my lord, Supreme Court has, when Supreme Court has mentioned the expression interim protection means.
Protection to the petitioner.
Yes.
That it, what I understand is that is protection from arrest
Could be.
till you approach this court.
Yes.
So you have to approach under
No,
appropriate.
All that I'm saying is, my lord, if your lordship says that in the meantime there will be no coercive measure, then I'll stand protected, my lord, because they cannot file a charge sheet. The clear authority on this point, my lord.
But they can arrest you.
Oh, certainly, my lord, once the lordship say they will no coercive measure, certainly they will not do, my lord. Coercive measure will also include a measure to, my lord, curtail my liberty.
No, you have also submitted that you are willing to approach.
Will cooperate with the investigation, that's a different nature. When a case is registered, I have to, my lord, as a law-abiding citizen, I can say no. But question is, in doing so also, there is some protection could be given by the honorable court.
No, I am not inclined to grant you protection from arrest during the pending.
In this proceeding, my
In
lord.
this proceeding for the entire period of investigation.
But lordship will say that there will be no coercive measure, my lord.
No. If you approach the appropriate court seeking appropriate remedy for protection against arrest, I may grant you some time.
No, lordship can hear this matter. Lordship, all that I am saying is, lordship can hear this matter immediately after reopening, my lord. Till then, lordship will say no further proceedings. My lord, let us go through the transcript, my lord.
Okay,
What is there in this case, my lord?
okay. Heard Mr. K.N. Chaudhary, learned senior counsel, assisted by Mr. T. Deori, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioner Abhisar Sharma, who is praying for quashing of the first information report number 7/2025, which was filed by the respondent number 2, Alok Barwa, on the basis of which Crime Branch PS case number what is the police station case number?
7 of 2025.
7 of 2025 was registered under section 152/196/197 of the Indian Penal Code. The gist of accusation in this case is that on 21/8/2025, one Alok Kumar Bora, within bracket respondent number 2, had lodged an FIR before the officer in charge of Crime Branch Police Station against the present petitioner, inter alia, alleging that the petitioner, with an intention to malign and disrepute the duly elected government of Assam and Union of India, has published and circulated an article through an online platform, YouTube, which contained statements ridiculing and denigrating the duly elected governments of Assam and Union of India. Stop. Learned counsel for the petitioner, learned senior counsel for the petitioner has submitted that in a democracy, what is your submission?
My under
Criticism.
Article 19, I have every right to, my lord, criticize the functioning of a government.
Criticism of the functioning of
Criticism, my lord.
government, which is fair in nature, does not constitute any offense under section 152/196 or 197 of the BNS. He further submits that the petitioner, prior to approaching this court by filing the instant criminal petition, had approached the apex court by filing writ petition within bracket criminal number 338/2025. In the said writ petition, by the order dated 28/8/2025, the apex court had issued notice in that case, however, only with respect to the challenge to the virus of section 152 of BNS 2023. However, so far as challenge to the FIR, which is FIR in question, the apex court did not interfere and granted interim protection to the petitioner for a period of 4 weeks to enable him to approach this court. And accordingly, the petitioner is before this court. On the other hand, learned additional public prosecutor has submitted that the in a proceeding under section 528 of BNSS, normally High Court should refrain from passing orders like no coercive action within inverted comma without clarifying the same. He also submits that if the petitioner is seeking protection from arrest in connection with this case, he may approach the appropriate court under appropriate provision of law, like seeking relief under section 482 of BNSS. Stop. He, in support of his submission, he has cited a ruling of the apex court in the case of Siddharth Mukesh Bhandari versus State of Gujarat, reported in 2023, 1 SCC, criminal 389. Stop. I have heard the contentions raised by learned counsel for both sides and have gone through the records of this case. Stop. It appears that the apex court had granted protection to the petitioner for a period of 4 weeks, which according to the submission of learned counsel would be over by today. today. Stop. The contention raised by learned counsel for the learned senior counsel for the petitioner in this criminal petition deserves an examination by this court, and therefore let the case diary be called for list. Let the case diary of the crime branch PS case number 7/2025 be called for. Stop. Let this case be listed again on 22nd of October. Stop. 22nd of October. Considering the fact that the petitioner was granted interim protection for a period of 4 weeks in this case, while relegating him to this court is inclined to grant same protection to him till arrival of the case diary. List accordingly.
With all respect to Learned Senior, but that the order is of 28/8/25. Today is 19, 4 weeks, not yet completed.
4 weeks lapse.
4 weeks not yet completed, 28/8/25 is the order, page 54.
In any case, by this time, it will be listed.
Yes, yes, but I have submitted.
Okay. Ito last line to cut off.
4 weeks.
Considering the fact, considering the fact that the protection granted by the apex court is for a period of 4 weeks, which would lapse on 27/9/2025. The said protection shall be extended till next date, till arrival of the case diary. List accordingly.
Yeah, please, Dora, I'm sorry for interruption, my lord. Item number 23, in case of the petitioner side has taken time, my lord, and it is your lordship has taken time, has given time, 3 weeks time. Kindly, that may be given, my lord, in this case, because I have
Date. Item number 23.
item
Date
number
attached.
23, it's admission, my lord,
27 of
27 of
item number
October.
23 change.
With regard to item number 22, Lordship, today is fixed for consideration of the interim prayer, Lordship. Lordship can take it as the last item.
If it reaches, I will take it.
22.
May please, Lordship. Lordship, in item number 20, Lordship, I just need to 1 minute time, Lordship. Lordship, may take this matter may be upgraded as because Lordship, tomorrow this matter was fixed before the trial court. And in this case, Lordship, the joint petition has been filed, husband and wife is a matrimonial dispute, and report has been sought whether compromise has been taken or not. Already report has been comes, Lordship. So, Lordship, if possible, Lordship.
We'll try to take it up.
Highlights.
My apology, Lordship, for mentioning this matter at this inherent time, Your Lordship. Lordship, I beg to mention the bail application, Your Lordship, where the accused has been arrested by violating some guidelines framed in Satyendra Kumar until case, Your Lordship, for listing on Monday, Your Lordship.
No, on a date to be fixed by registry.
Lordship,
On-
otherwise it will be, if Lordship permits, Your Lordship.
No, we are full on Monday. On a date to be fixed by registry.
Lord, can I take little liberty of making a mention of a matter? Item 62, my lord, the matter is fixed before the trial court tomorrow. Can I pray, my lord, in case if it doesn't reaches around 3:30, lordship will call the matter, or 4 o'clock, any time convenient, the lordship.
We'll try to take up.
Yes.
as- Yes.
Lordship, please come to page number 28,
What is the matter?
Zimma petition.
Zimma বা oil tanker মেলা report necessary.
It was rejected. Yes, yes.
Rejected. Lordship.
Now, what is your submission?
Which one is that? In the same incident, some other vehicle was also seized and they have been released on Zimma, Lordship. Only my vehicle is still detained in the police custody.
Now, what is the error in the judgment? Error in the order, impugn order. Well,
All other vehicles that was seized in the same incident, Lordship, that have been released on Zimma.
But
On
every,
page number 26.
what is the ground for rejection?
Page 28 মেলা
Report has been called for and was submitted by the IO and which was considered by the learned magistrate Lordship and relying upon the same, they rejected the Zimma petition.
There are two, the same vehicle was carrying the oil which was stolen and sold for illegal financial gain.
And I had no knowledge about this and.
You are the owner.
Yes.
Yes.
Let the report be called for from the IO matter. It's not.
Already.
No, IO's report is already there. If he is the owner, where is the statement that you don't have any knowledge? You have made that statement in your criminal petition. Where is that statement?
Page number 4, fourth para, Lordship. They had misused my vehicle, Lordship, without my consent.
Heard. Miss, what is your name?
P. Kundu,
T.
appearing on behalf of.
P. Kundu, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioner, namely Joydeep Das, impugning the order dated 4/8/2025, passed by learned Subdivisional Judicial Magistrate M. Margherita, whereby the prayer for granting Zimma of the vehicle bearing registration number AS23BC 2691, which was seized in connection with which case?
Digboy PS case number 101/25.
Igbo PS case number 101/2025 was rejected. Learned counsel for the petitioner has submitted that the petitioner is the registered owner of the seized vehicle and he had no knowledge regarding use of his vehicle for some illegal purpose. He has submitted that the vehicle was misused without his consent or knowledge. She further submits that in the meanwhile, the other vehicles seized by the investigating officer in the same case where is that order?
Page number 20. Okay.
has been released in custody, has been given in custody of the respective owners. However, merely on the basis of the report of the investigating officer regarding involvement of the vehicle in the commission of the alleged offense, the learned magistrate has passed the impugn order without taking into consideration the fact that the vehicle in question was used for illegal purpose without the knowledge or consent of the present petitioner. You have anything to say? I have considered the submissions made by learned counsel for both sides and have considered and have perused the impugn order. There is nothing on record to show that the petitioner had consented to use of his vehicle for illegal purpose or that he had any knowledge of the said fact. Stop. The petitioner is where is the RC? Petitioner is the registered owner of the seized vehicle as apparent from the copy of the registration certificate of the seized vehicle annexed along with the instant criminal petition. Stop. The apex court has observed in the case of Sundar Bhai Ambalal Desai versus State of Gujarat, reported in 2002, 10 HCC 283 as follows. Quote para 17 from the aforesaid judgment. In the instant case also, it appears that what was the date of seizure?
12/6/2025.
It appears that the vehicle has been, where it is lying,
Decoy Police Station.
lying in the campus of the Digboy police station for last 3 months. And there is also nothing to show that the vehicle is further required for the purpose of investigation. Under such circumstances, the vehicle in question ought to have been given in Zimma to its registered owner. In view of the observation of the apex court in the above cited case. Stop. Considering the above facts, this criminal petition is disposed of by setting aside the impugn order as well as directing the release of the vehicle, directing the investigating officer of Digboy PS case number 101 of 2025 to release the said vehicle. What is the cost of the vehicle? Approximate cost. How much?
Oil tanker is
10 lakhs.
no, oil tanker is more than 20-30 lakh.
What is the cost?
Around 15 lakhs.
You are saying on what basis?
In the petition. motion.
लिख ले. vehicle
Not like
on the petitioner, 15 lakhs. On petitioner furnishing a bond of rupees 15 lakhs with an undertaking to produce the vehicle before the trial court as and when so required by the trial court. At the time of giving the Zimma of the said vehicle, the investigating officer of Digba PS case number 101/2025 shall prepare an inventory of the said vehicle and also take photographs from various angles and thereafter send the bond, inventory and the photographs to the trial court for keeping this same with the records of the Digba PS case number 101/2025. This criminal petition is accordingly disposed of.
Item 69 from supplementary.
Pay to the lord. My lord, before I proceed with the facts of the case, my lord, I would pay, my lord, while going through, I find, my lord, there was earlier a criminal petition against the same charge sheet, my lord. That record may be called upon and this may be placed in the next day. My lord, this is the order copy in earlier criminal.
By whom?
By the same petitioner, my lord.
Then this is not maintainable.
My lord, that is because that was on the same different grounds.
But on different grounds, you cannot file successive, you have to withdraw. In both the cases, you are the petitioner.
That was disposed of. That was
Disposed of.
disposed of. That was disposed of. That is.
It was rejected.
Not rejected, my lord, because the respondent informant came before the court and said the ground was taken. They said they will not go with the Naraji petition. That was the.
Okay, heard.
My lord, one thing, my lord, your lordship, will give me a liberty to file an affidavit to correct some prayers portion. My lord.
Okay. Heard Mr. P.K. Roy Chaudhary, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Learned counsel for the petitioner submits that and on an earlier occasion, the petitioner had approached this court by filing an application under section 482 of the Code of Criminal Procedure, which was registered as criminal petition number 393/2018. He submits that said record may be necessary for consideration of the instant criminal petition, hence prays for placing the said record along with this record of the instant case. The prayer is allowed.
That record may be called up.
The learned counsel for the petitioner also prays for allowing the petitioner to file an additional affidavit or
Some corrections. In the prayer.
For that, I
will fail it.
file an interlocutory application seeking some corrections in the
Present application.
in the present application. The prayer is allowed. Let this case be listed on 23rd October along with the case record of criminal petition number 393/2018.
Mr. Kayal is on late lordship. I matter maybe take Monday lordship. No lordship. Already you have taken so no lord. Maybe your lordship. No lordship.
Don't start fighting. Let her submit first. Then you raise your objection after she completes her submission. You need not to interrupt. Yes.
Lordship, Mr. Kayal is on late lordship. Today some difficulty lordship. Finally it's Monday.
Monday, it may not be. Yes. What is your submission? They are seeking adjournment.
They are bail application pending since March lordship. They are taking adjournment lordship.
No, today you are seeking adjournment.
Chief, Kyle sir already, he is in Lexon, code number 3. I have meet to him also, your lordship. For the time being? No, lordship, we are for the time being, some judgment, lordship, today not available, fix it Monday, lordship.
Monday, it is not possible.
Tuesday, lordship.
Oh,
If this person is in custody more than 1 year, 6 months, your lordship, and the eight of the witnesses, no any witnesses has been processed.
how much is the contraband? Of? Then
Lordship, 1 year, 6 months, more than 1 year, 6 months, your lordship. They are the types of lordship. Do you think delay of the trial, your lordship?
no, I am now deciding whether to adjourn the case or not. I am not hearing the matter. If the prayer for adjournment is rejected only, then hearing would start. When can you argue?
Tuesday, lordship. If possible, Monday, lordship.
25th. 25th of September. Heard Miss A. Medhi, learned counsel for the petitioner. Also heard Miss N. Kakoti, learned additional public learned counsel for NCB.
Yeah.
DRI, who submits that learned standing counsel, DRI, is on legs in a different court and therefore prays for a short adjournment. Considering the submission, though learned counsel for the petitioner has raised objection to the prayer for adjournment. However, considering the submissions made by learned counsel for the petitioner, the prayer is allowed. Let this matter be listed on 25th of September 2023.
Please, your lordship. Your lordship, trial has already started, lordship. And 23-9, it is fixed for consideration of charge. I would rather pray, lordship, let the trial proceed little bit. And
Item
this-
number?
29, lordship.
Yes, what is your submission?
Lordship, my submission is this, that it is fixed for consideration of charge on 23-9, lordship.
Yes.
So let the trial, if the trial has already started, the trial proceed for this informant statement be recorded. Till then,
It
this
is a
bail-
POXO case,
No, lordship, it is an NDPS. case.
NDPS case.
Till then, this bail petition may be kept pending and it may come up after Puja vacation, lordship. Because charge sheet has already been filed, lordship. Otherwise, I am in custody, lordship, may kindly.
Charge sheet has been filed.
Yes, lordship. I am in custody, lordship, for 178 days, lordship. And I am not on
No.
merit. I was on ground of arrest, but since now already trial has started, lordship. Fixing 23-9 on for consideration of charge. Let the trial proceed little bit, lordship.
You are sure that charges will be framed against you? There are materials.
Yeah. Apart from the ground
Then
of arrest,
37 will come if there are materials.
lordship. Apart from ground of arrest, lordship, there are seizures. I will to be very fair enough. There are seizures, lordship, of 30.875.
You can take this plea before the trial court, ground of arrest.
I would rather pray, lordship, let this bail petition be kept pending till
No,
the vacation, lordship. Till that, if the informant comes and we are able to demolish the evidence of then we'll file an additional affidavit, lordship, before this honorable court.
no, can come again. How much is the contraband
30.875 kg, lordship,
of?
ganja.
Yes, Mr. Sharma.
Also, in fact, this application was filed at the time of investigation. After lordship, on the last occasion, we had submitted that charge sheet has already been filed. Their lordship, then they, on their request, lordship, this scan copy was called for. Now, lordship, here in the scan copy, it is seen that cognizance already been taken. And now it is fixed for consideration of charge.
Consideration of charge.
So, lordship, they can always approach the court below and then they can approach again.
Otherwise, on merit, it has to be decided.
It has to be decided.
So you have two options. Either I dismiss it or you withdraw it.
Do it, lordship, with the liberty, lordship.
Liberty is always there in heard Mr. M. Bhattacharya, sorry, heard Mr. A. Bhattacharya, learned counsel for the petitioner. Also heard Mr. K. B. Sharma, learned additional public prosecutor. Learned counsel for the petitioner has submitted that since the charge sheet has been filed, the petitioner intends to approach the trial court and therefore he seeks leave of this court to withdraw the instant bail application. The prayer is allowed. This bail application is dismissed on withdrawal.
Deeply oppressed.
Item 30. CD has not been received.
Madam, this is the fourth consecutive date, madam. CD not, prosecution going to produce case diary.
Commercial
And this
quantity.
case, madam, what happened, I am the police personnel, madam. And I am the victim of the disagreement with my colleagues, madam. Because there is no possession from me, madam. How I can be involved, madam? Only in FIR, there is written one line in page 15, madam.
Why are you not producing the case diary?
Lordship, a prayer has been forwarded by the IO Lordship.
I have sought some time.
For providing one more opportunity, Lordship, for producing the case. Otherwise, it's a commercial quantity. Case.
And
Before vacation, my lord, any bit. Otherwise, my lord, since last, before vacation, my lord.
what is your ground?
Ground, my lord, nothing recovered from me. Only saying that there was spot interrogation, one of the accused person from whom it was recovered, they mentioned my name. Although not is mentioned, only my lord, the phone number, the mobile number which linked with my mobile number. This is the only ground. And what the ground is that, my lord, I am the police personnel, my lord. The person who arrested, who earlier was my driver of my vehicle, my lord. So for, and also near my locality, my lord, for which there was a contact between them and.
Heard Mr. B. Sharma. I mean, no, heard Mr. S.H. Sigdar,
HR Chaudhary.
sorry. Heard Mr. H.R. Chaudhary, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who seeks some more time for production of the case diary. The prayer is allowed. Let this matter be listed when.
After vacation.
My lord, before vacation and date, my
No,
lord.
Lordship, this is commercial quantity.
My lord,
Where
only,
grounds, Lordship, your statement of.
I am nowhere engaged, my lord.
Lordship, regarding the implication, Lordship, we have to produce the CD. And Lordship, this co-accused statement, paper part of Lordship trial. Now it is an investigation stage. So Lordship, all these facts, Lordship, has to be done from the case diary. Lordship.
No, what materials are there?
Lordship, the telephone contact with the main accused, it is there in the forwarding itself, page 19.
My lord, I am a police personnel. I am
Lordship,
external
regarding
police
Tufan Singh,
constable.
Lordship, that has to be ascertained after the trial, Lordship. It is an investigation stage. So whether Tufan Singh will be applicable at the investigation stage, Lordship.
No, suppose an accused
Yes,
calls you on your mobile phone
yes,
and your mobile phone is reflected
yes,
in his
yes,
call detail records.
yes,
And he states before the police that you are also the recipient.
yes.
Then, and under such circumstances, when no other evidence is collected,
No other evidence, Lordship, till when, Lordship? The investigation has to be
so
done,
for
Lordship.
180 days, you can be detained behind the bars.
Yes,
That has to be examined.
yes, Lordship, because otherwise, Lordship, if they file a bail application within 20 days and say that there is no evidence against me, how can Tufan Singh be applicable in 20 days, Lordship? I'm just giving an example, Lordship, whether that can be said. It is up to the police
This
officer to conduct the investigation.
26th September, it is required to be answered.
My lord.
31.
That is a question. This regular bail application, Lordship, the petitioner was arrested in connection with the strength of NBW, Lordship. And otherwise the case is sent all pending, Lordship. And the
Oximeter.
Lordship.
Oximeter,
No, Lordship.
NDPS.
Lordship, NDPS, and 21B, Lordship. And Lordship, the,
case diary is there.
no, Lordship, and already.
Charge sheet petal.
Charge sheeted, Lordship.
What is your case?
And out of Lordship, 9 witness, Lordship, all the witnesses examined, Lordship.
What is the date of your arrest?
Arrest, Lordship, actually, he was arrested in connection with the other case, Lordship, in Gwalpara, and subsequently he is produced.
In this case, when you will,
This case is produced from the Gwalpara jail, Lordship, and on 2011-2024.
2011, 2024.
Lordship, and second page, Lordship, and that case already been granted bail.
So you are on what ground you are seeking bail?
Lordship, and
How will you overcome 37?
witnesses examine, Lordship, and there is.
This examination
Commercial one.
is not, will not help you.
Intermediate quantity.
Intermediate. Intermediate one.
It is intermediate quantity. Okay.
So, my lord, and the witnesses examined, there is no concretely reveals against the accused, Lordship. And so considering the length of detention, Lordship, the rest of the Lordship and remaining trial will be faced, Lordship.
You were produced before this, in this case, when?
And 2011-2024, and firstly, Lordship, kindly come to page number 37, Lordship.
Lordship, may I place the facts, Lordship?
Yes. You have to be fully prepared. You are not ready with the answers posed by the court. Or I can give you time to get ready. Instead of PP helping you. You cannot come to the court on the hope that PP will help you in stating the facts also.
But otherwise, Lordship, the witnesses, some witnesses examine, Lordship, and I am in question.
Guess what are the facts?
Lordship, here the FIR was lodged on 20/01/2013.
13.
13, yes, Lordship.
13.
That is why it is important, Lordship. He was arrested on the same date. He was forwarded, Lordship. Then, Lordship, will find it very interesting, Lordship. The charges were framed on 18/3/2013. Lordship, will kindly note.
Yes.
18th March 2013. Charges were framed, Lordship, against 2 accused persons, including the present petitioner, Lordship.
Yes.
Thereafter, Lordship, because it is a intermediate quantity, he was enlarged on bail on 9/5/2015.
Yes.
Then, Lordship, what happened, Lordship? He remained absent without steps from 10/9/2013 on 18 consecutive dates. Thereafter, his bail application was rejected, Lordship.
When he was arrested?
Arrested on the same date of FIR, Lordship, 18/3.
No, thereafter
Thereafter, yes,
he defaulted.
He defaulted, Lordship, on from 10/9/2013. He defaulted on 18 consecutive dates.
What has happened?
Yes, after that, I'm coming to that, Lordship. May I continue, Lordship?
No, just please maintain the decorum in the court. Anybody not maintaining decorum will be liable to contempt jurisdiction. Yes.
Yes. When, Lordship, he was first granted bail on 9/5/2015. Then,
Yes.
Lordship, what happened? He remained consecutively absent, Lordship. Then, Lordship, again he preferred a bail application and he was given bail on 4/10/2016.
No, when he was arrested,
On the date of FIR itself.
the second time when he did not,
Uh, 9/5 15, he was first enlarged on bail. Thereafter, Lordship, he remained absent, so and so. Then Lordship, I have to again peruse the CD, but Lordship, his bail was, again, he was granted bail on 4/10/2016. 4/10/2016. He was again given bail, Lordship. In that bail condition was there, Lordship, that he will not indulge in any such offences, Lordship. That is always there, Lordship. Now, Lordship will kindly see from the petition, Lordship will kindly see page number 35. In the meantime, Lordship, if I may just clarify, by that time, Lordship, 8 numbers of PWs were already examined. Lordship, will kindly come to page 35. Out of 10.
Yes.
This order, Lordship, will kindly see.
How much was the contraband?
Lordship, and 13.
Yes, Mr.
Their Lordship.
Sharma, continue.
Yes, Lordship, their Lordship, this order, Lordship, will kindly see. 15, first Lordship, will kindly see page 37. I'm sorry. 37, Lordship, will kindly. This is order dated 18/12/24. Here Lordship will directly come to the last paragraph. On perusal of the case record, it appears that the accused persons were enlarged on bail and they defaulted in appearance for which warrant was issued against them. Subsequently, they were produced before this court on 20/11/24. On the strength of warrant pending against them and on the very date they were taken into custody. The record also transpired that warrant is still pending executions against another co-accused, namely Chandan Bhumi. The learned advocate had assured the accused person will face trial by appearing on each and every date fixed and they will provide a suitable bailer if released on bail. Considering the submission, they were granted bail. What you will think that? Now, Lordship will kindly come to page 35.
Yes.
This order, the order I have just shown, Lordship, it was of 18/12/24, and now this order is of 15/7/25.
Yes.
Lordship will see paragraph number 3, seen petition number so and so under section so and so, seeking regular bail for accused Tarak Biswas, the present petitioner, who was arrested on the strength of NBWA issued against him due to his absence without any step for several previous occasions. Perusal of the record reveals that the case is at the last stage of evidence, and today also further examination chief and cross of PW7 is recorded. Now only one witness remained to be examined. This was on account of absconding of accused Tarak Biswas as well as the other co-accused since deceased.
One is died.
Here and case has already been abated against the other co-accused. It appears that after several years of absence, the accused was arrested on the strength of NBWA and subsequently he was released on bail. But the accused absconded for the second time and again NBWA had to be issued, and after several attempts he was produced from Goalpara jail where he was detained in
Yes,
connection.
your conduct does not inspire confidence.
And it is not finished also, Lordship. Therefore, there is every possibility as it appears from the conduct so and so, Lordship. Now, Lordship, he was arrested on a similar offense.
NDPS case.
Yes, NDPS case, that is special NDPS case 1 of 2012 and was released on 20/12/24. There also, Lordship, he did not appear, Lordship. So
In that case, that is pending trial.
Yeah, pending trial, but the status I don't know, Lordship, because on the record it is not.
He has not appeared.
I cannot say, Lordship.
Okay.
But Lordship,
But your conduct is not good. How many total number of witnesses are there?
Total 9, Lordship, and
9.
8 is
Oh.
already completed.
Let one be examined and let trial be concluded.
It was fixed on 9/9/25.
Heard Mr. F. Hawk, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Tarak Biswas, who has been detained behind the bars since 9/11/2024, within bracket for more than 1 year, for about more than 10 months in connection with NDPS case number 7/20/2013 under section 22B/29 of the NDPS Act 1985. Learned counsel for the petitioner has submitted that the petitioner has been facing trial in the NDPS case number 7/2013 pending before the Court of Learned Special Judge NDPS Kamrup under section 20.
22B.
20.
29.
Within bracket B, Roman 2,
20B to C,
not C,
No,
Lordship,
not C,
capital
Lordship.
B.
20B to B/29 of the NDPS Act for possessing
14 kgs of ganja.
14 kgs of suspected ganja.
Two person lordship, two accused. And from my possession 14 kg and the another one, the Gopal Devnath and 8 kg. That is different,
14 kg.
14 kg.
And from the co-accused, 8 kgs of suspected ganja was recovered. Learned counsel for the petitioner has sought for bail on the ground that petitioner has been languishing behind the bars since more than 10 months and already 8 out of 9 listed prosecution witnesses have been examined. On the other hand, learned additional public prosecutor has vehemently opposed the grant of bail to the petitioner and has submitted that it is because of the conduct of the present petitioner, the trial in this case, which is of the year 2013, is pending till date. He submits that petitioner was earlier granted bail. However, he failed to comply with the conditions of the bail and failed to appear before the trial court. He also submits that he even indulged in committing similar offense under NDPS Act as a separate, as another NDPS case, that is NDPS case number 1/2012 was registered against him, in which he was arrested. Learned counsel for the petition, learned additional public prosecutor further submits that the trial is nearing its culmination and only one witness is remaining to be examined. He, however, submits that if the bail is granted at this stage and if the petitioner defaults again, there is every likelihood, the NDPS case number 7/2013, which is pending for last 12 years, may not be disposed of. I have considered the submissions made by learned counsel for the both sides and have gone through the scanned copy of the records of NDPS case number 7/2013. It appears from record that the conduct of the petitioner after getting bail in this case on earlier occasion does not inspire confidence that he would abide by the conditions of the bail and would cooperate in the trial. Stop. This court is therefore reluctant to grant bail to the petitioner at this stage when the trial of NDPS case number 7/2013 is nearing its culmination. For the aforesaid reasons, the prayer for bail is rejected.
Deputy Judge. Like,
None has appeared for the petitioner on call. It is there. Let this matter be listed.
On 19.
Charge sheet has been laid.
Yes. On
Learned counsel for the petition. Learned additional public prosecutor has submitted that though the case diary was called for, however, in the meanwhile, charge sheet has been laid bearing charge sheet number
67/25 dated 5/9/25.
stop. In view of the fact that charge sheet has been submitted in this case, this bail application is disposed of with an observation that the petitioner may approach the trial court and may pray for regular bail before the said court, if so advised.
44. Charge sheet submitted.
What is the offense?
Bank, Bandhan Bank matter lordship.
Huh?
Bandhan Bank Nalbari matter.
Okay.
Earlier the question was on bail, but letter was rejected.
Heard Mr. Raj Sharma,
From 8.
learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that though the case diary was called for, however, charge sheet has been laid bearing charge sheet number
56/25 dated 17/9/25.
2020. Considering the fact that the charge sheet has been laid in this case, this bail application is disposed of with an observation that the petitioner may approach the trial court and may pray for regular bail application before said court if so advised.
The court shall pass, proceed as per law. That may be.
Court always proceeds as per law.
45.
Public. I played the lordship for equity bail petition. That case that was called for. I was arrested on 8/8/2025. Last 43 days I am behind the bar. My lord, kindly see FIR is in page 14, but a relevant person. Allegation is my lord illegal money transaction. I am the not name accused, my lord, in the FIR, my lord. And all the accused person have been released on bail. My lord, already. My lord, considering the length of detention, my lord, I may be allowed to go on bail, my lord. I will not hamper and tamper with the evidence, my lord. I will fully cooperate with the investigation, my lord.
What is your name?
My name is Lord
Pritam.
Pushpendra Singh.
Alias Rohan Singh.
Pushpinder.
Yes, my lord.
You are not named in the affair.
Yes, my lord. My lord, I was arrested and I was taken 3 days police custody. Thereafter, my lord, I have been thoroughly interrogated, my lord. That is, my lord, kindly see forwarding report, my lord, Annexa 3, page 19, my lord. During the period of custodial remand, he was thoroughly interrogated. Probably, my lord, other custodial detention may not be required for the purpose of investigation, my lord. My lord, all accused person, name accused person already released on bail. Even, my lord, one of the accused person who have been arrested.
Yes.
Lordship, interrogation is necessary, Lordship. Investigation is in initial stage, Lordship. And Lordship, crore of rupees, Lordship. Bank after going through the bank account analysis, investigation revealed 15 bank account linked to the accused person, including 3 current accounts and 12 saving accounts. Detailed analysis of transaction of statement revealed Pushpendra Singh Panwar, Lordship this petitioner, credit and debit 2,77,24,690. These current accounts were conclusively used by an online gaming operator as mole account to facilitate illegal transaction, Lordship. And Lordship, there is a gang, Lordship. 11 persons are still absconding, Lordship. To Lordship, another gang and to Lordship. And Lordship,
My lord,
also Lordship, it is in initial stage, Lordship, arresting of remaining accused person, verifying bank account, getting PAN and tax info, cryptocurrency investigation, all our Lordship, this interrogation is necessary, Lordship.
my lord, allegation is there, but my lord, considering the length of days and moreover, my lord, already all the name accused person released bail, my lord. Even my lord, who was arrested along with me, my lord, that person has been also released on bail, my lord. My lord,
But materials are there again.
yes, my lord, if materials are there, my lord, definitely, my lord, search it will be filed, my lord. If evidence will be found against me, my lord, definitely I will be convicted. But at this stage, my lord, I have 43 days behind the bar, my lord. 60 days mandatory period, my lord. All the allegations, my lord.
Lordship, this is a serious
So
state to
considering the length
financial
of detention, my lord,
integrity,
I will not hamper and tamper with the evidence. Fully cooperate with the investigation, my lord. Already police has stated in the courting report that he has been thoroughly interrogated, my lord.
Lordship,
Probably further custody may not be required, my lord, for the
It's
purpose of
required,
investigation, my lord. Well, I will fully cooperate, my lord. Already-
Mr. B. Buragohai, learned counsel for the petitioner, also Miss N. Das, learned additional public prosecutor. This application under section 483 of BNSS has been filed by Pushpendra Singh Panwar, alias Rohan Singh, who has been detained behind the bars since 8/8/2025 within bracket for last 43 days in connection with Vishwanath Sarali PS case number 105/2025 under sections 61 within bracket 2/318 within bracket 4/316 within bracket 2/318 within bracket 2 of BNS, read with section 43/66/66 D/66D of Information Technology Act. The gist of accusation in this case is that on 23/5/2025, one Rajdeep Newar had lodged an FIR before the officer in charge of Vishwanath Police Station, inter alia, alleging that on receipt of an information through reliable sources that a network operating in illegal money transaction has been reported to have been operating in various parts of Assam with its center at Vishwanath. Accordingly, the police arrested 3 persons named in the FIR. Learned counsel for the petitioner has submitted that the petitioner has not been named in the FIR and he has been detained behind the bars for last 43 days. He further submits that the petitioner was also remanded to police custody and he is now detained in judicial custody and therefore his further custodial interrogation may not be necessary. He also submits that the offense involved in this case entails maximum punishment for how much punishment?
7 years.
Not more than 7 years. And therefore, 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 the maximum period of detention for which he may be kept behind the bar under during investigation stage is 60 days. He also submits that the petitioner is ready to cooperate in the investigation. On the other hand, learned additional public prosecutor has vehemently opposed the grant of bail to the present petitioner and has produced the case diary of Bishwanath Sir NDPS case number 105/2025. She has submitted that during investigation, it has been revealed that the petitioner has 3 savings bank account and 12 current account, in which suspected monetary transaction to the extent of more than 2 crores was noticed. She further submits that the petitioner there are other materials in the case diary which implicates the petitioner in the offense alleged in the FIR. She also submits that there are many other co-accused persons who are yet to be apprehended, and considering the fact that the offense involved in this case is in the nature of economic offense, she prays for rejecting the application for bail at this stage. I have considered the submissions made by learned counsel for both sides and have gone through the case diary. Stop. Though the petitioner has been detained behind the bars for last 43 days, however, considering the nature of accusation and the materials available in the case diary against the petitioner, coupled with the stage of the investigation, this court is of considered opinion that this is not a fit case to grant bail to the petitioner at this stage of investigation. The prayer for bail is therefore rejected. Send back the case diary. This bail application is accordingly proposed.
Lordship, it is third day. Earlier PCR was called for Lordship but not received. Petitioner is behind the bar for 5 years, 7 months, and 18 days. Lordship.
Where is from which court it will be coming? We are prosecution has no role in it. It is the trial court which is failing to send the record. Heard Miss S. Nazneen. What is your name? S. Nazneen, learned counsel for the petitioner. Also heard Miss M. Deka, learned counsel for NCB. It appears from the office note that the scanned copy of the case record has not yet been received, in spite of requisition sent for the same by the registry of this court on 11/9/2025. Registry to issue reminder for the scanned copy. The superintendent of concerned section of this registry shall also telephonically intimate the Chief Administrative Officer of the Court of London, Session Judge Kamrup, to send the requisition scanned copy from the Court of London Additional Session Judge within bracket FTC number 5 Kamrup without fail before next date. Let this case be listed again on 26th of September.
Item 38.
May I plead your lordship? Accused is behind the bar for last 706 days.
Can copy not received, lordship. And notice also, lordship.
Proxometer,
FIR is on page number 13.
notice has not been served.
Yes, sir.
It has been served.
On the 4th of this month, I have taken step.
You have taken step, but service report is awaited. Let the additional public prosecutor take the information. Heard. What is the case under section?
Under case under section 75 IPC 75 to 350
75 to 351 2 of
and
PNS.
section 12.
Read with section 12 of POCSO. Lord.
Your Honor, may I read the FIR please
No.
once?
But we will require.
Nothing is there in this case. Page number 13 is the FIR. Even if all this statement is admitted, no case will be made.
Where is the FIR shown?
Page number 13, 1-3. May I read?
No, let me go through. No, offense is made out. It is.
But section 12 does not attract by all this activity, and he is behind the bar for last 106 days. Considering
106.
yes,
Let the notice be served. Heard, Mr. What is your name?
are they?
R.D. Learned Counsel for the petitioner. Also heard Miss N.D. Das Learned Additional Public Prosecutor. It appears from the office note that this scanned copy of the trial court record has been received. However, service report in respect of the notice issued to respondent number 2 is awaited. Since learned additional public prosecutor is requested to take information regarding fate of the notice issued to respondent number 2 from the officer in charge of the jurisdictional police station, and let this court know about the same on the next date fix. Let this matter be listed on 25/9.
$25 of this month. Published.
Item 49.
May I plead your lordship? Here in this case, lordship, that
Can copy not
co-accused.
received, no?
Received, sorry.
Received?
Received. That co-accused is already granted bail by this honorable court, lordship, court in advance, page 66 here, lordship will find.
But this trial court records have not been received.
Earlier that the lordship directed to check with along with that bail application, lordship, that bail application is there. So records are there.
trial court records are same.
It's not there.
Trial court records are not there.
So
It is NDPS case.
NDPS. It is from the FIR itself, it is admitted that the co-accused and I was apprehended on the same day from the same vehicle. And the co-accused is granted bail by coordinate bench. Lordship. That order is also there. I
Where?
am not relying on any disputed documents. Lordship.
What is your submission?
My submission is that I was arrested along with the co-accused on the same day from the same vehicle, Lordship. And the co-accused is granted bail considering the length of detention, Lordship. I am on same footing.
How long you are behind?
1 year, 9 months, 16 days. And out of 37 witnesses, 1 witness partly examined.
I have not gone through the case report, Lordship.
It is already
Sometimes
there in the order, coordinate order also, it is already reflected, page 66 also.
What is the contraband?
Heroin, Lordship, 375 grams.
You go through the scan copy. Let her go through.
After
Tomorrow, Lordship?
It take a
Sure.
longer time.
Monday, Lordship.
You can take much longer than that. कितने दिनों पड़े?
Monday, Lordship, already it is admitted, Lordship, that they were traveling together.
Okay, Monday. Heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor. Learned additional public prosecutor seeks some time to go through the scan copy of the trial court record. The prayer is allowed. Let this case be listed on 22nd September.
Alright.
Rako. It's okay. Okay.
There was a
It-
direction to list the coordinate, co-accused bail application, Lordship, along with this.
It appears that it appears that you verify from the records whether is it there or not. It appears that it appears on perusal of the office note dated 5/8/2025, which shows that the scan copy of the trial court records have been received. However, no such scan copy was found on with the records. Registry to verify and list the matter again on 22/9.
Alright.
The direction was there to file a rejection order, but it's from Romania Lordship that we did not obtain the Lordship. And now the case that is here, the earlier the person was arrested, 2 persons were arrested, and later on after 11 days I was arrested, and from my position 1.3 gram was recovered. They suspected to be heroin.
Where is the bail rejection order?
That we could not obtain, Lordship. That is from Romania court, Lordship. And we have asked one Lordship, but he could not get out from the record.
In the meantime, Lordship, initially the case was registered under intermediate quantity. Now on the prayer of the IO, commercial quantity has been added, Lordship.
Even then, after 11 days recovery from my position, Lordship, that will be matter, Lordship, that 1.37. After 11 days of lodging of the FIR, Lordship, it would been.
You take some time and file the
Yes, let them file this.
rejection order. We'll keep the case ready. That is necessary. Otherwise, the application may be rejected on that ground, on not following the notification. There is. Heard Mr. S. Muni, learned counsel for the petitioner. Also, Mr. B. Sharma, learned additional public
Lordship,
prosecutor.
may I take 2 minutes, Lordship? I'll have the instruction to withdraw it or Lordship, file a phrase,
Okay.
Lordship. 2 minutes, Lordship.
Okay.
I'll inform him, Lordship.
We'll take it up after some time.
Lordship.
41.
Forty-one.
In this case, Lordship, 1013 has been there, Lordship, of BPX, they suspected the Alpha Linkman and Alpha Cadets, Lordship. Wherein many people were arrested and Lordship have pleased to grant all of them, considering the materials in the case diary, Lordship. At this situation, Lordship, I will pray that Lordship will.
What is the date of your arrest?
My date of arrest is Lordship 5/7/2025, Lordship.
For how long?
76 days. And earlier, many persons have approached before this court and Lordship has also granted 3-4%. The bill I have granted one, I have annexed one order which Lordship have granted, but all are of different footing, Lordship. Okay.
Yes. What is your case?
I also, Lordship, they don't suspect it was
Suspicion.
Lordship, the case there will reveal, Lordship, what is my actual.
Yes, Mr.
But he has collected the phone numbers and all people of various businessmen and forwarded to the Alpha. That is the main accusation. I have talked to the IO also.
But now 76 days he is behind you. Heard Mr. S. Muni, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Mridu Pavan Gogoi, who has been detained behind the bars since 5/7/2025 within bracket for last 76 days in connection with Crime Branch PS case number 2/2025 under section 61 within bracket 2/147/308 within bracket 2 of BNS, read with section 10/13 of Unlawful Activities Prevention Act 1967. The gist of accusation, quote para P from page 27. You are named in the affair? No. Quote para.
FIR is of April later part.
Quote para 4 from quote para 5. Quote para 6. No, don't quote para 6. Learned counsel for the, on the other hand, learned additional public prosecutor has produced the case diary of the Crime Branch PS case number 2/2025 and has submitted that there are sufficient incriminating materials against the petitioner. He submits that there are materials that the present petitioner used to collect the phone numbers of various businessmen and provide the same to the members of a proscribed Alpha I organization. He further submits that the investigation is still going on, and if the petitioner is granted bail at this stage, it may hamper the investigation stuff. I have considered the submissions made by learned counsel for both sides. Considering the nature of accusation made against the present petitioner and the period of detention already undergone by him, that is 75 days, this court is of 76 days. This court is of considered opinion that if he cooperates in the investigation, his further custodial interrogation may not be necessary for fair completion of the investigation of Crime Branch PS case number 2 of 2025. In view of above, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Session Judge Kamrup Metro with following conditions. Condition number 1 and 2. Send back the case diary. This bail application is accordingly disposed of.
Lordship, the earlier case item 40, Lordship, I beg to withdraw that same, Lordship, with the
40.
liberty to file.
Heard Mr. S. Munir, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned counsel for the petitioner. Praise for allowing the petitioner to withdraw the instant bail application. The prayer is allowed. This bail application is dismissed on withdrawal.
Much obliged, Your Lordship. Much obliged. Much obliged.
None has appeared for the petitioner on call.
Charge sheet submitted, my Lord.
Learned counsel for the learned additional public prosecutor has submitted that though the case diary was called for, however, in the meanwhile, charge sheet has been laid bearing charge sheet number
72/2025, dated 28/8/2025.
stop. In view of the fact that charge sheet has been submitted in this case, this anticipatory bail application has become infructuous and accordingly disposed of.
So, my Lord, CD not received.
Heard Miss J. Ghosh, what? Heard Miss A. Day, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, who prays for some more time for production of the case diary. Prayer is allowed. Let this matter be listed on 24th October.
Service people also I will obtain, my Lord.
The service report in respect of the notice issued to respondent number 2 is awaited. Await further. You say, I'm not mentioning it.
24 October.
Item 45.
CD not received, my Lord. 45 and 53 are same. Yeah.
I am for 45.
45. Interim is there.
You're on interim bill.
Yes.
Heard Mr.
Yes, sir.
S.
Sarkar.
Sattar, learned
Sarkar.
S. Sarkar, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, who seeks some more time for production of the case diary. Prayer is allowed. Let this matter be listed on
29th, my Lord.
29th of October. The interim order shall continue till next day. This was similar to
53, my Lord.
53, who is the counsel?
No, no.
We are for 53, item number.
You are on interim bail.
Yes, Lord.
What is your name?
S0, Your Lord.
S.D. Roy. Same order, earlier order,
2910, my Lord.
2910.
48 are same, my Lord. CD not received. 46, 47, 48, all are in interim.
Yes.
46,
46, 47, 48, my Lord.
same order.
Police station is Lotashi nearby.
Heard Mr. I. Rafiq. You are on interim bail.
Yes.
Heard Mr. I. Rafiq, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, who seeks some more time for production of the case diary. Prayer is allowed. Let this case be listed
38th of October, my Lord.
on 30 October. The interim bail granted to the petitioner will continue till next day. 46, 47, 48, same order.
Yeah, please, Your Lordship.
allegation under section POCSO Act, my lord.
CD and service, CD not receive and service report also required. No?
Heard, Mr. What is your name?
Abu Ahmed.
M.U. Ahmed, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. The case diary has not been received and learned additional public prosecutor has sought some time for production of the same. Prayer is allowed. The service report in respect of respondent number 2 has also not been received. The learned additional public prosecutor is requested to take steps, requested to take information regarding fate of the notice issued to respondent number 2 from the officer in charge of jurisdictional police station and let this court know about the same on the next date fixed.
16th of October.
Let this case be listed on 16th October.
51. One thing is though case is second time has come but earlier rejected by Justice Ranjal Das that court is sitting malad.
It will go to that court. Heard Mr. S.K.S.N. Muhammad, learned counsel for the petition. Also Mr. K.K. Parashar, who submits that this is for the second time the petitioner is approaching this court by filing an application for anticipatory bail. It is submitted that his earlier anticipatory bail application was rejected by the coordinate bench of this court, within bracket Honorable Mr. Justice P. Das. Stop. In view of above, registry to verify the same and lays the matter before appropriate bench.
Can I fix a date?
Registry to fix it.
Is CD available in that case earlier is CD available. 52.
52.
The notice steps have also been taken because
Also, you have not taken steps.
we have taken steps, my lord.
Not Mr. I.A. Jurika, learned counsel for the petitioner. Also at Mr. K.K. Parashar, learned additional public prosecutor, who submits that, who prays for some more time for production of the case diary. Prayer is allowed. It also appears that service report in respect of the notices issued to respondent number 2 has not been received. Learned public prosecutor, learned additional public prosecutor is requested to take information regarding the fate of notice issued to respondent number 2 from the officer in charge of jurisdictional police station and let this court know about the same on the next date fixed.
17th of October.
Let this case be listed on 17th of October.
Very good, my lord. They have 438 application, my lord.
Lakhimpur malad.
It will be difficult.
One try can you give it.
Otherwise, we take service report again. If not repaired, then
Amicus could not have been appointed in that case, or not, because
After receiving the report,
because
17th October.
October, yeah. One transient you can take, my lord.
it may not come. It will go to tomorrow, malad, and
No, it is not
20?
possible. Only few days are left. Few days are left.
Because if a lawsuit goes to the FIR, no allegation is there. If kindly for a minute, madam.
No.
Praising.
Without CD, I am not going to.
There is no allegation. Only section is there, but there no whisper is there regarding
Okay.
any physical.
If I don't find it justified, then I will reject it now without paying.
Only FIR has that.
If I find the material,
FIR, no physical, nothing is there. Madam. That they have done any physical relationship, allegation of physical relationship, you can go to the FIR only. If lawsuit feels that.
to 26, 9.
Because only for that, and now they have compromised. Madam. Actually, he is the petitioner is the brother-in-law of the.
26/9.
My lord, for consideration of bail, suspension of sentence.
Notice was issued, Lordship.
304 part 2. 7 years. My lord. Only one eyewitness. My lord. Only see page 19.
Yes, Mr. Sharma.
So notices were issued to be.
Notices are not served. Service report has to come. When have you taken steps?
Served.
We'll wait for one more chance. Heard Mr. S.K. Ghosh, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Have you taken steps?
Yes. Has been served. Main.
On perusal of the flag X, last. On perusal of the office note dated 17/9/2025, it appears that the notices issued to the respondent number 2 has been received back without service with an endorsement that addressee expired, return to sender. Stop. I have considered, yes, what is the submission?
My lord, consideration of bail, only PW8, kindly see page 19. Page 19.
Yes.
Only this, eyewitness, my lord. PW8.
No, what is your case? One witness is sufficient.
Yes, I am showing that there is in eyewitness also, there is no material against him.
Okay.
That I want to show.
Since when you are behind the bars?
He is behind the bar, my lord, after passing of the judgment, and prior to that, during trial also, during investigation, he was for
7 years imprisonment.
7 years.
You have any objection?
I would like to argue on the merits of the case, but Lordship.
There is a judgment of the apex court in Kiran Kumar's case.
Yes.
Which says that if it is a short-term imprisonment, normal rule is to grant unless you can show something exceptional. Is there anything exceptional in this case?
Exceptional, Lordship, firstly, they will have to submit, Lordship, that they have a good case in appeal, Lordship. There are
I'll show, my lord. I'll show the only one eyewitness is sufficient to explain that whether there is any.
That's okay, Lordship, because the trial court has also recorded that in a elderly person, Lordship, his conduct was also good, Lordship, because after.
Okay. Heard Mr. S.K. Ghosh, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 430 of BNSS has been filed by the petitioner, namely Kamalendu Dev alias Konu, praying for suspension of the sentence imposed on the applicant by the judgment and order dated 19/6/2025, passed by learned additional session judge Kachar, learned additional session judge within bracket FTC Kachar, in sessions case number 87/2011. So by the aforesaid judgment, the petitioner was sentenced, was convicted under section 304, part A, part 2, and was sentenced to undergo rigorous imprisonment for 7 years and to pay a fine of rupees 10,000 and in default of payment of fine to undergo simple imprisonment for 6 months. The petitioner was also convicted under section 325 of the Indian Penal Code and was sentenced to undergo simple imprisonment for a term of how much?
1 year.
Simple imprisonment for 1 year and to fine. You have not mentioned properly in the cost.
Page 854, Lordship.
And to pay a fine of rupees, no fine. No fine. He was also convicted under section 34, 341/34 of the Indian Penal Code and was sentenced to undergo simple imprisonment for 3 months. Simple imprisonment for
30 days.
30 days.
30 days.
Fine 1,000.
And to pay a fine of rupees 1,000. And in default of payment of fine?
No.
Then you don't pay that fine.
Actually,
Where is the judgment?
page 8,
54.
page 8. Page 8 of the IA. Actually, wording is something.
Learned counsel for the petitioner has submitted that the petitioner has impugned the aforesaid judgment by filing the connected criminal appeal number 290/2025, and he is hopeful of getting a favorable result in the said appeal. He further submits that only one prosecution witness has deposed against the present petitioner, and his testimony is also contradictory. Stop. He further submits that considering the fact that the petitioner has been sentenced to a short-term sentence of 7 years only, he may be allowed to go on bail, unless he may be allowed to go on bail and the execution of sentence imposed on him may be suspended during the pendency of the connected criminal appeal. Unless same is done, there is a likelihood of criminal appeal filed by the petitioner becoming infructuous. On the other hand, learned additional public prosecutor has submitted that there are sufficient materials against the petitioner on the basis of which the trial court had convicted him by the impugned judgment, and there is unlikelihood of him getting a favorable result in the connected criminal appeal. I have considered the submissions made by learned counsel for both sides. Since the connected criminal appeal has been admitted for hearing, and since the the sentence imposed on the petitioner is for a short-term period of 7 years. If the sentence is allowed to run parallelly during the pendency of the connected criminal appeal number 290/2025, there is a likelihood that for all material purposes, the appeal filed by the petitioner may become infructuous, as large number of criminal appeals are pending in this court. For the aforesaid reasons, this court is of considered opinion that this is a fit case where, in exercise of powers under section 430 of the BNSS, the execution of sentence imposed by the impugned judgment may be stayed. This court accordingly does the same. Further, during the pendency of the connected criminal appeal, the petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the learned additional session judge FTC Kachar in sessions case number 87/2011, with a condition that in the event of dismissal of the connected criminal appeal number 290/2025, the petitioner shall surrender before the trial court to serve out the remaining part of his sentence imposed by the impugned judgment. This interlocutory application is accordingly disposed of. In appeal, they have heard both the parties. On perusal of the office note, it appears that the notice issued to respondent number 2 has returned with an endorsement that the addressee expired. Stop. It also appears that the records of the trial court has been received. This appeal is ready for hearing. Hence, let this appeal be listed for hearing after 8 weeks.
Wait, this is the Lordship, this application is filed for correction of modification of conditions of bail conditions, Lordship. The petitioners were granted bail on 11/10/2018, Lordship. The conditions your Lordship will find at page 24. Starts from para 34. I'm seeking modification of page 24 if your Lordship comes. Condition para 34, condition B and condition E.
Just a minute.
The prior permission, I need to take prior permission before going beyond the territorial jurisdiction of the learned special judge, Lordship. So I'm seeking modification of the same on medical grounds, Lordship. I have annexed the medical documents of the mother and father of the petitioner, Lordship. So the father underwent a liver transplant surgery and the mother is a heart patient, Lordship. So they have to keep on going outside Guwahati for treatment, Lordship.
This investigation is still pending.
No, Lordship, the trial is going on. Now.
So, you approach the trial court.
No, Lordship, since the order was granted by this court, the trial court asked us to approach this court, and similarly placed persons have already been granted the benefit. I have annexed the order. The Lordship comes to page 39, annexure 3. The operative part is at page 40, Lordship. I'll regularly appear, Lordship. So here the conditions were relaxed, Lordship. Page 40, the order is there. The same conditions were thought to be modified, and the Honorable Court, after hearing the parties, my learned senior friend was also there in that matter, Lordship.
Whose leave was required?
The leave of the learned trial court, Lordship.
No, what is the difficulty in taking leave?
Lordship, no, at times because of the medical urgency, Lordship,
it becomes impossible for us to take the permission because the court is not functioning, and if the court is not there, so it's serious condition. The father is a liver transplant, liver patient, Lordship, and the mother is also.
You are otherwise appearing.
Yes, Lordship. I'm appearing regularly, and
Yes.
I'll keep on appearing, Lordship.
Heard Mr.
MP Chaudhary.
MP Chaudhary, learned counsel for the petitioner. Also heard Mr. P.P. Dutta, learned additional special public prosecutor. This interlocutory application has been filed by the petitioner, Srimati Deepshikha Paul Okon, who is praying for modification of condition imposed while granting bail to the petitioner by order dated 11/10/2018 in bail application number 2307/2018. Learned counsel for the petitioner submits that the petitioner is regularly appearing before the trial court and has been cooperating in the trial after getting bail in which case
Special case number 2/17.
sessions case.
No, special case number 2 of 2017.
In special case number 2/17, pending before the Court of London,
Special judge.
Special Judge Assam. However, learned counsel for the petitioner submits that as the parents of the present petitioners are ailing and suffering from serious ailment like
The father underwent a liver transplant surgery, and the mother is a heart patient.
liver ailment as well as heart ailment, she has to accompany her parents outside Assam frequently and sometime on emergency basis. And under such circumstances, it becomes difficult to take prior permission from the court before leaving the jurisdiction of the trial court. And therefore, he submits that the condition B attached to the bail order dated
B and E, Lordship.
B and E. What
Yes.
is E?
E, your Lordship will find it page 25.
Condition B and E. Yes. Attached to the bail order dated
11/10/2018.
11/10/2018, passed in bail application number
2307 of 2018.
2307 of 2018 by a coordinate bench of this court may be modified. On the other hand, learned additional public prosecutor submits that the petitioner is regularly appearing before the trial court. Stop. I have considered the submissions made by the learned counsel for both sides. Considering the reasons showed for seeking a modification of condition B and E attached to the aforesaid bail order, as well as considering the fact that the petitioner has been complying with the conditions of the bail and is cooperating in the investigation, in the trial, this court is of considered opinion that considering the circumstance under which the petitioner is seeking modification of the bail order, modification of the aforesaid condition, said, comma, the said condition seems to be onerous for the petitioner in case of medical emergency of her parents. Accordingly, this, the aforesaid condition, that is condition B as well as condition E attached to the aforesaid bail order shall be regarded as deleted. Deleted. And
Modified.
and the bail order and the aforesaid bail order is treated to be modified accordingly. This interlocutory application is accordingly.
However, Lordship, that paragraph 8 of the earlier similar order may be put, Lordship.
Will
What-
appear regularly
That
before the
page number.
trial.
No, other conditions are already there.
Lordship, my friend is saying that the para 8 of page 40,
Page
your
40.
lordship may come.
No, but that condition is already there in the bail,
Yes,
that he will cooperate.
Will cooperate.
If you, yeah, I am appearing regularly. and
Other condition remains on
only
this.
PNE is modified.
BNE. This bail application is according,
I
this
think that-
interlocutory application is accordingly disposed of.
Lordship, the same order for next item will also do. Same matter. The parents of the petitioner herein are suffering from various ailments, Lordship. For that, he has to leave the territorial jurisdiction. And related to, I have stated in paragraph 4,
Petitioner are different.
different, Lordship. The order is same. That was a common bail order. The petitioner herein is different. It's Rituraj.
And circumstances are also same.
Yes, medical lordship. His father is suffering from severe problem related to lung disease, lordship, interstitial lung disease, and his mother is also suffering from thyroids, lordship. So they are undergoing treatment at regular intervals, lordship. And he has certain business also, that also I have stated in paragraph 4, lordship. I'll comply with all the directions. I'll appear regularly.
Same order with disease to father or lung ailments and mother are suffering from thyroid ailment. Same order.
Yes.
This
Highly
also.
obliged, highly obliged, lordship.
May I please, your lordship? Your lordship, we have taken the steps for the private respondent today, your lordship.
Oh, yeah.
Postal Talagona, your lordship.
Miss, what is her name?
Steve.
Yes, the learned counsel for the petitioner who submits that the petitioner has taken steps for issuance of notice on the private respondent today only, and therefore seeks an adjournment of this case. The prayer is allowed. Let this case be listed now. When? After? No, after 4 weeks, the interim order shall continue till next day. But when you are interim and you are not taking steps as directed by within the time granted by the court, the interim is liable to be vacated. So, okay.
Lordship, I'm appearing on behalf of counsel Ms. P. Borg. Lordship, she has recently suffered bereavement, your lordship. Lordship, as per the office note, your lordship, our services come unanswered.
You take fresh steps.
Lordship, I want to submit one thing, Lordship. Lordship, if Lordship will come to page 20, Lordship, that's the address they have put in the complaint case. They have preferred, Lordship, and we have preferred service upon that address only, Lordship. Here's the address they have put in their complaint case, Your Lordship.
Yes. Addressee absent. He may remain present and the next time. So you take fresh steps. Heard Mr. What is your name?
P. Khatun, Your Lordship.
P. Thakuria, Learned
P.
Counsel.
Khatun, Your Lordship.
P. Khatuniar, Learned Counsel for the petitioner. On perusal of the office note dated 17/8/2025, it appears that notice it's issued to respondent number 1 has returned with a postal endorsement within bracket the addressee absent, comma RTS inverted comma close. It also appears that the record of the trial courts have also not been received. Issue reminder for the same. The petitioner shall take fresh steps for issuance of notice upon the respondent by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks, list accordingly.
Your Lordship. This is higher for my lord delay condoning of 15 days only for preparing appeal, Lordships.
Taken steps, issuance of notice.
No delay condoning for delay, Lordship, only 15 days, Lordships. And my lord, state is the party.
State is the
party.
State and my lord, this, my lord, still wildlife also, my lord, but I have, my lord, B. Sharma, he has instructed me, my lord, 15 days, he has no objection. On behalf of B. Sharma, my lord.
And this is item number 59.
59.
Heard Mr. M. Hawk, Learned Counsel for the petitioner. Also heard Mr. PP, also heard Mr. KK Parashar appearing on behalf of Learned Special Public Prosecutor Wildlife. This application under Section 5 of the Limitation Act has been filed by the applicant for condoning the delay of 15 days in preparing the connected criminal appeal, whereby the applicant intend to impugn the judgment dated 13/6/2025 passed by Learned Session Judge Baksa in special WL within bracket P case number 12/2018. Learned Counsel for the petitioner applicant has submitted that the cause for approaching this court belatedly after 15 days beyond the 15 days of the period of limitation has been mentioned in para
10, Lordship. Para 10, page
in
7.
para 10 of the said instant application. Considering the cause shown by the petitioner, Learned Additional Public Prosecutor raises no objection to the prayer for condoning the delay. Stop. I have considered the submissions made by both sides, Learned Counsel for both sides, and have gone through the record. The cause shown by the applicant in paragraph number 10 of the application for condonation of the delay appears to be sufficient cause. Moreover, considering the concession, considering the submissions of Learned Counsel for both sides, this court is inclined to condone the delay of 15 days. Accordingly, the said delay of 15 days in preferring the connected criminal appeal is hereby condoned, and this interlocutory application is accordingly disposed of. Registry is directed to register the connected criminal appeal and leave the same for admission on a date to be fixed by it.
LCR.
No, register, criminal appeal has to be.
Sorry, Lord, yes.
60.
Yeah, please, Your Honor. This is a matter investigated by the CIT after taking from the state police of the Manipur. And because of the law and order situation, it has been transferred from Manipur to here by the Honorable Supreme Court. What happened, Your Lordship? The charge sheet has been filed before the court below. And there was a prayer with regard to the 173A. This is an armed looting case from the Indian Reserve Battalion. As many as 400 to 500 persons came there and they have looted the arms after breaking the lock and key.
Why, what this limitation? This application is for,
This is under section 482, but with due caution, this limitation we have prayed for if there is any delay in
but there is no limitation for 482.
482. There is no limitation, however, but here it has been filed, they have been taking a due caution.
No, but there is no legal requirement. Therefore, this,
This has already been approved by the DCBI, so I could not able to delete the same. Otherwise, it will again go back to up to Delhi and then it will come. So,
so should I dismiss it or you will withdraw it? This is not meant. Heard, Miss. Yes. Heard, Miss M. Kumari Lanet.
If this portion I am not placing,
No, where is your 482 petition? Heard,
that is not written, and then I shall withdraw Your Lordship.
heard, Miss M. Kumari Lanet, Special Public Prosecutor on Standing Counsel.
And
Lanet's Standing Counsel. No, it cannot be anything. It has to be.
it is written both standing counsel, retainer counsel, as well as special PP for the purpose of criminal cases.
Special PP, special.
So in the
Learned
notification, all these words are there.
Special Public Prosecutor CBI, who prays for allowing to withdraw this interlocutory application. The prayer is allowed. This interlocutory application is dismissed from withdrawal. And the connected,
I may be given a Lordship permission to file.
as there is no limitation period prescribed by law for approaching this court under section 528 of BNSS. The registry is directed to register the connected criminal petition and leave the same for motion on a date to be fixed by it.
Item 61.
I need not have to file a press. Lordship.
61,
61.
same,
Much obliged.
same order.
Yeah. Much.
60 and 61 you are appearing.
60. Only in 60.
Okay, 61. Okay.
I prefer the criminal division measure. There is delay of 9 days measure in preparing measure. And only PP, only government is the party measure. So,
What is the case?
about the release of seized vehicle.
You are objecting?
Okay.
9 days only.
No.
Heard Mr. S. Chauhan, learned counsel for the petitioner. This application under section 5 of the Limitation Act 1963 has been filed by the petitioner, namely Inzamul Haq, praying for condoning the delay of 9 days in preparing the connected criminal revision petition, whereby the petition applicant is intending to impugn the order dated 27/1/2025 passed by learned Special Judge Udalguri in Udalguri PS case number 116/2024. Learned considering the fact that only 9 days of delay has been caused, learned additional public prosecutor raises no objection to the said petition. Stop. Considering the cause shown by the petitioner in the application for causing delay and treating the same to be sufficient cause, the prayer for condoning the delay of 9 days in preferring the connected criminal petition is hereby allowed, and the delay of 9 days is hereby condoned. The registry is directed to register the connected revision petition and list the same for admission on a date to be fixed by it. This interlocutory application is accordingly disposed of.
Made please, Lord. My lord, we have filed this IA in this pending criminal petition number 55 of 2020, my lord. If your lordship would kindly come to page number 11 of that IA, my lord. Uh,
11.
Page 11, my lord, of the IA 1056 of 25.
Yes.
Your lordship would kindly come to the last para towards the bottom of the page. Mr. Bora sought for stay of further investigation in Olumen police station case, which is strongly objected by MS Bhattacharya, referring the context of Annexure 4 in the writ petition, which is a prayer made by respondent number 5 in order to add the subsequent section under Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act 89 in the said case number 5 of 2020. As the issue involved in this writ petition is in respect of jurisdiction for investigation, I am of the considered opinion at this stage that till the returnable date, the investigation of Olumen police station case is the state, which I accordingly allow. Milord, this order was extended, Milord. Last, it was extended on, and page 18, Milord, this order was modified, Milord. Now, if the lordship would kindly come to page number 18, Milord. The order starts at page, please come to page 19, Milord. Earlier, the investigation was state, Milord. Then this order is dated 23/7/2020, para 4 at page 19. I make it clear that let the investigation go on so that process of investigation does not suffer on account of pendency of this case. Till the next hearing of listing, no coercive steps be taken against the petitioner. Now, my lord, this was the order. Till the next date of listing, no coercive steps be taken against the petitioner. My lord, this particular order, there is one more aspect, my lord, in this case. Please come to paragraph 6. Considering that both the accused and the complainant are police officers, the petitioner being an IPS officer and complainant belongs to Assam Police Service, it would be appropriate that investigation is supervised and monitored on day-to-day basis by Additional Director General of Police CID. the entire investigation conducted would be considered by Additional Director General of Police CID Assam, and a decision would be taken by the investigating agency only with concurrence of the Additional Director General of Police CID. So, my lord, two observations were made. First, earlier there was a complete stay on investigation. This honorable court said no. Investigation should go on, but the investigation should be supervised by an officer not below the rank of Additional Director General of Police. Then, my lord, will kindly, this order was tested before the Supreme Court, my lord. And the Supreme Court order starts at page 21. If I may have your lordship's kind attention to page 23. Para 6. We dispose of the present proceeding with the clarification that directions contained in paragraph 3 of the order of the High Court shall not constrict the duty of the investigating officer to investigate into all aspects of the complaint, nor do they confine the investigation to documentary materials. So, my lord, investigation part was permitted by the Supreme Court, but on no coercive measure, my lord, Supreme Court did not say anything. In other words,
Who
no
approached the
coercive-
Supreme Court?
This is the order I read just now.
No, who approached Supreme Court?
The other side. Informant.
Okay.
Informant. Then, my lord, now, my lord, now I would like to place one judgment of the Supreme Court, my lord, on the purport of what is the meaning of, my lord? No.
Now what has happened?
Now, my lord, now we have essentially raised the issue of territorial jurisdiction. That point is to be gone into. Now, tomorrow is the date fixed. Now, our grievance is, my lord, without supervision of the Additional Director General of Police, the charge sheet has been filed. Subsequent proceedings have also taken place where challenge, matter went to Supreme Court also, those are there. But this order of no coercive measure is still continuing. So therefore,
Charge sheet has been laid.
late. Now, if your lordship would kindly come to page 25, my lord. Page 32. That's the order, charge sheet. Please come to page 32, my lord, Roman 13.
Yes.
The accused police officer Gaurav Upadhyay in his WPC number so-and-so filed before the Honorable Guwahati High Court raised objection on the ground of lack of jurisdiction against the registration of the instant case in All Women Police Station case and investigation conducted by All Women Police Station and Criminal Investigation Department, Guwahati. But Honorable Guwahati High Court by an order dated 21/10/20 allowed investigating officer to continue the investigation of the police case in accordance with law. Earlier, the Honorable High Court by order dated 23/7/20 in connection with the criminal petition number so-and-so linked with AB number so-and-so issued an order as follows. I make it clear that let the investigation go on so that process of investigation does not suffer on account of pendency of this case. My lord, everything has been said, but in the charge sheet, my lord, two aspects has not been highlighted. One, that there was also an order for no coercive measure. And secondly, my lord, that investigation was to be supervised by an officer of the rank of Additional Director General of Police. Now, my lord, what is the effect of this no coercive measure? I have placed an order of the Supreme
No,
Court.
before that.
Yes.
This connected criminal petition has been filed by you.
Yes.
Challenging what? The charge sheet.
FIR itself. And secondly, my lord, there are some regarding the competence of the learned session just to take up the matter. Because, my lord, it is the additional. No, Lordship is asking about this petition.
This petition.
Oh, this petition we have filed against.
This is an interlocutory application.
Yes. Listen.
Filed in connection with
Yes,
a criminal petition.
A sale, please come to the prayer portion at page number 21.
In the criminal petition.
It's a Initially, it was filed as a writ petition, my lord, that is 258 of 2020. Subsequently, it was registered as a criminal petition number 55 of 2020. A writ in the nature of certiorari should not be issued. Set aside and quash the impugn FIR registered as all women police station case under so-and-so, read with section 10 of the offense. No,
Criminal petition.
it was petition.
This criminal petition, you are challenging the,
Registration of the FIR by
FIR.
the all women police station on account of territorial jurisdiction part.
okay,
Because the incident have alleged occurrence took place in Defamation. And the case was registered in all women police station case, my lord. And at the relevant point of time, the mother of the victim was the superintendent of police of CI.
okay.
So basically, we challenge, my lord, their territorial part. That's why this honorable court raised, while passing that order of further stay of investigation, that aspect is recorded. Now,
Sorry.
our case is, my lord, since there is an order for no coercive measure in such a situation, whether the charge sheet could have been laid. Now, according to our humble submission, my lord, going by the law laid down in this case,
Where is the no coercive measure?
yes, my lord. No coercive measure that I have placed, my lord, at page 32. It was, no, sorry, page 19, my lord, of the IA. Para 5. Till the next date of listing, no coercive steps be taken against the petitioner. Thereafter, the matter was listed
That
on
is
once only when the order was extended.
Okay.
Subsequently, also, whenever it was listed,
Now, what is your prayer in the
my
instant?
charge sheet could not have been laid. If your lordship would kindly have the order of the Supreme Court, one-page order which I have given.
Yes. Yes.
Peruse the affidavit of Sri Deepak Kumar, Deputy Superintendent of Police, and Sri Tarakeshwar Prasad Kesari, Investigating Officer, and Sri Dayanand Kumar, Station House Officer. They have stated that they have read the order of this court, which directed them not to take any further action against the petitioner, as an order directing that no coercive action shall be taken against the petitioner. They have relied upon a letter dated 15th of April 2011, addressed by the Additional Director General of Police Jharkhand to all police officers in the state. It is stated in the letter that even if the court passes an order that no coercive action shall be taken as against the particular accused, there is no prohibition on filing charge sheet against the accused. If a charge sheet is filed by relying upon clause 3 of the letter dated 15th of April 2011 against an accused in whose favor there is an order directing not to take coercive action, the concerned officer will expose himself to contempt jurisdiction. Therefore, what is stated in paragraph 3 of the letter dated 15th of April 21 is completely illegal. We direct learned counsel appearing for the state to invite attention of the Additional Director General of Police to the observation of this court. We expect him to immediately modify the letter dated 15th of April 2011. The apology tendered by the three officers is accepted and no further action is called for against them. Hence, notices of contempt is discharged. So, my lord, the Honorable Supreme Court took the view, my lord, that whenever there is a order for no coercive action, it would imply that there is a prohibition on filing charge sheets. Because this letter of 15th April of the Additional Director General of Police stated that even if there is such an order, there is no bar in laying the charge sheet. So the Honorable Supreme Court says no, this is not correct position. So our case is also simple, my lord. Now, since this no coercive measure is holding the field, therefore they could not have laid the charge sheet.
So what relief you are seeking in this?
No, my lord, for the present, lordship will examine this matter, my lord, this IA, prayer made in the IA. For staying further proceedings, my lord, till lordship decides the matter on the jurisdiction. of the All-Women Police Station to investigate the case.
Lord, may I please correct? Lord, assuming for a moment that we actually believe whatever my respected senior has submitted, my lord. The charge sheet was filed way back on 31st of March 2021. And we are at 2025. So more than 3.5 years. You have passed. appeared in the
Yes.
trial.
Yes, my lord, actually, the charges have just been framed, but after the charge sheet was filed, they've appeared. They've appeared. In fact, my lord, there was an order whereby the charge sheet was first filed in Guwahati. However, since the PO was in default, they had challenged that. And there is a consented order from this very court where they have never raised that. My lord, that order is there. My lord, dated 17th of November 2021, my lord. I'm just placing that order before your lordship, my lord.
With lordship's kind permission, can I take leave? My friend would be there. Court, another court, I think someone will. Deeply.
Yes, where is the order?
My lord, so sorry, I lost track of whatever I was referring to, my lord. So, my lord, there is a consented order transferring the matter to default dated 17th of November 2021, my lord. In this particular matter, they had actually challenged the charge sheet itself. My lord, the order, that order is before your lordship, my lord. My lord, if your lordship kindly goes to the
This
third
order is passed in this,
Yes, yes, my lord.
in this case, no?
Yes, my lord. Yes, my lord. The third paragraph, my lord. Several other grounds, my lord, has it for your lordships?
Yes.
Several other grounds have also been taken challenging the entire proceeding on various accounts for committing irregularity in the investigation and different other aspects. But at the initial stage of the motion itself, the learned counsel for the informant as well as the learned counsel for the state have submitted that they have no objection if the case is transferred to the court of the learned special judge at Diffu for conducting the trial. The learned counsel for the petitioner has also agreed to the above submission. So, my lord, here what I would like to point out is that several other grounds were taken. However, amongst these grounds, and I have the application with me as well, where they had preferred rather than repetition as regards the filing of the charge sheet, where they have never mentioned. My lord, may I be permitted to even place the application before your lordship? It's quite voluminous, but
It is there in
prayer
the
part.
record.
No, man. It is in a different matter where they had actually challenged this, the charge sheet itself, where I am placing before your lordships the application which they had
No,
passed, based on which this order was passed.
This present criminal petition is criminal petition number 55.
My lord.
Where they have
My lord,
challenged the FIR.
actually, during this period of 3.5 years, there's been a lot of water that has flown under the bridge. Matter has been taken up by the trial court, has been dealt by this court itself on a different subject, but relating to the same issue. It has been taken up by the High Court and has also gone up to the Supreme Court, wherein they have never ever challenged or taken up this plea. Where they are seeing now that court, because there is a word coercive action, the charge sheet could not have been filed. I'll take your lordships to a division bench judgment as well, my lord. But before that, I would just like to place this, that this very order, which is a consented order, this application based on which this order was passed, they have never taken that ground amongst the other grounds which have been specifically mentioned, where the court says that several other grounds have been taken, but this was never taken up. Further, my lord, if your lordship goes back to that order passed by Honorable Justice Rumi Kumari Fukan, my lord, further below, the third paragraph after the paragraph that I was referring to, as has been submitted
My lord, has it, if your lordship?
Yes.
As has been submitted, the entire cause of action arose in default. And in view of section 177 of the CRPC, trial of such case should be conducted within the jurisdiction where the offense was committed. Now, my lord, without discussing any more about the merit of the case, as the parties have already arrived at a consensus for trial of the case before the special judge at default, in the interest of justice, let the entire proceedings pertaining to sessions case so-and-so, now pending before so-and-so at Kamrup, be transferred to the court. Nothing here as well, my lord. Now, my lord, there is another matter, my lord, where they had sought for anticipatory bail, my lord. That is an order dated 7th of January 2021. My lord, may I be permitted to place that order before your lordship? My lord? Here also, my lord, nothing as regards coercive steps as they have now chosen to take up, my lord. Nothing as regards that. Now, my lord, there is another order passed by the Honorable Supreme Court dated 11th of September 2020, my lord, which is annexed to their application itself. My lord, I would wish for this court to revisit that order, which my respected senior had just read out.
Page number?
My lord, it is dated page 21 of their IA. The order starts at page 21. And the operative portion, which I would like to rely upon, where they have so conveniently dodged, is at para 5, my lord. Page 23, my lord, the operative portion.
Yes.
My lord, at this stage, since the investigation is in progress, we are not entering upon any aspect of the factual controversy. We clarify that the observations contained in paragraph 3 of the impugned order of the High Court dated 23rd of July 2020 are not intended to, nor can they confine the authority of the investigating officer to investigate into the complaint fully and effectively in terms of the powers which are vested under law. So, my lord, here, the IO has been given complete authority. Nothing here as far as coercive steps are concerned. It was never brought up before the Honorable Supreme Court as concerned.
Their submission is different. Their
lord.
submission is that
My lord.
because of the observation made by the apex court in the contempt case,
Right now, my lord.
contempt case which they are relying.
My lord, at best, my lord, I'll come to that. I'll satisfy your lordship as regards
So
that.
there, what I have understood that their submission is whenever word no coercive action to be taken against the accused is used by the court, in such case, before filing the charge sheet, you have to seek leave of the court.
Right.
That is the limited submission.
Correct, my lord. Now, my lord, this very aspect, coercive steps, has been actually removed by an order of the division bench, my lord.
Okay. In this case.
My lord, in this very case. My lord, that is an order dated 21st of January 2021. It is a division bench order, my lord, which is, it will be on in the records, my lord. This is in the reply that we had preferred against the criminal petition. My lord, usually a reply is not preferred, but in this matter, we had actually filed a
This
reply.
is in a writ appeal.
No, my lord, it is in the criminal petition. And the writ appeal, my lord. I'm so sorry.
The writ appeal against which order?
Writ appeal number 2. One minute. Writ appeal number 2. Writ appeal number 2. My lord, it will at page 69 of our reply, my lord. Yeah. My lord, I'm so sorry, my lord. A loose copy has been probably furnished by the bench system. The same order, my lord, where we had actually filed this as an annexure to our reply in the criminal petition, my lord. My lord, at page 69, where I've given, my lord, the relevant portion, it is in the writ appeal, my lord. 190, writ appeal 190
69 now?
My lord, that is in our reply, but a loose copy has been furnished before your lord. My lord, writ appeal number 190 of 220, my lord.
Yes, where is your reply?
My lord, that
In this
reply-
interlocutory application.
No, my lord, it is in the criminal petition, my lord.
Affidavit in opposition. Reply to sir.
Perhaps there would be just one reply
Yep.
by the
These
respondent
are
number 5, if I'm not wrong. So this is at page 68 of our reply, my lord.
Reply, written reply, page 68. Yes,
My lord, page 68 of, your lordships has it before your lordship.
page 68 of the
My lord, the reply was filed in the month of March 2020.
reply against their criminal petition.
Well, that is what I said, my lord. Usually it is not done, but just to bring certain facts and to put the entire matter in perspective, we had preferred this reply.
Give the record to them.
My lord, in the meantime, my lord, while
You may
my
continue
colleagues-
submission.
My lord, yes, my lord. So, my lord, that copy of that writ appeal, the judgment of that writ appeal has been placed before your lordships. It is in case number writ appeal 190 of 2020, my lord.
Yes.
My lord, if we,
This writ appeal was referred against which order?
my lord, I'm coming to that, my lord. It was regarding an SC/ST issue which was raised before this court as well, if I'm not wrong, my lord, where it was dealt with by this court as well. So that is a parallel issue, my lord. But having said that, my lord, if we come to the conclusion, my lord, paragraph 8, my lord, of this very order, paragraph 8, my lord,
Yes.
this court has also been informed by Mr. K. Goswami, learned counsel for the appellant, that as per his information, the investigation has already been completed. If this is so, the normal procedure and consequences shall follow. So, my lord, that part where they are hinging upon that coercive action should not be taken, wherein charge sheet should not be filed, has been nullified by this order of the division bench, my lord.
Yes.
Now, my lord, to come to the question which has fallen from your lordship, my lord, as regards whether if the word coercive action is there, whether a charge sheet can be filed or not. One, my lord, it has been taken care of by this order of the passed in this writ appeal, my lord. And moreover, my lord, that the charge sheet was filed in 2001, my lord. 2021, my lord. So what would happen to that? Even if we go by their submissions in their order, my lord, the order that they're relying upon, passed by the Honorable Supreme Court, at best there can be a contempt proceedings against the officers. That we are ready, man. But has the charge sheet been nullified or has it been just thrown out of the court? It is, the court has not done that, my lord.
Yes.
The charges have been framed. So now, my lord, at this stage where there is a POXO matter, where somehow we have been somehow.
Now, whether are you facing trial?
No, my lord, the only reason, my lord, let me just finish, my lord. I'll just
Yes.
take 30 seconds.
Yes.
The only reason, in fact, he had gone to he has approached the Supreme Court even 10 days back, where their matter was dismissed. The only reason is that he does not want to appear before the trial court. That is the only reason. Since tomorrow is the date, that is why he has filed this application today. And when I say he, I mean the accused. In a matter which actually has become infructuous. So his only intention is to avoid the trial. That is the only intention. Tomorrow is the date where he'll be explained the charges. That is all. So he wants to avoid that. So now by hook or by crook, he is relying upon this and that. That is all.
In any view of the matter, if your lordships take up the criminal petition, in criminal petition, mainly lack of jurisdiction issue is there. That lordship ground never has been dealt with by any of the court, lordship. That criminal petition is still pending, lordship.
Then why did he go to the, why did he approach the Supreme Court, my lord?
Those were different aspects, lordship. Those are not connected with the present case. If my learned friend can show any of the petitions which I approach or they approach, lordship, targets the issue, touches the issue of jurisdiction, I have no case at all. Then I will submit with your lordship that my criminal petition is infractious, that may be disposed of. I will submit that part. But that is not the case here, lordship. None of those jurisdictions, because your lordship probably remembers that the earlier criminal petition which was filed before this court, that the learned session judge do not have jurisdiction under section 20th POCSO Act. That has been lordship disposed of by this honorable court. So this is a different aspect, lordship. And when he already filed the criminal petition way back in 2020, lordship, here.
Now, why this is pending for so long?
So even in fact, if your lordship sees order of the criminal petition.
This criminal petition is why it is pending so long.
Well, it was not listed. In fact, my lord, the last occasion where it was listed was probably on 8th of April 2021, my lord. So it was never listed before the court.
Well, let us dispose of this.
That may be disposed of.
My lord, and as far as the jurisdiction aspect is concerned.
Even in fact, if your lordship peruses the order dated 4/6/2020 of passed by this honorable court in criminal petition, considering the lordship issues involved, one amicus curiae was also appointed, lordship, because we have two persons. Those are two big persons are involved here, and lordship subject matter is lordship regarding malice is also there.
No, but this criminal petition cannot go on forever.
Yeah, that may be disposed of. That I have no objection on that, lordship.
My lord, if the criminal petition is disposed of, can the IA be allowed to continue?
Because tomorrow is the date expression of charges are framed, then it will be difficult for him, lordship. So lordship may either dispose it of the criminal petition any date, lordship. Immediately after vacation, lordship may fix it.
No, you appear before the court tomorrow.
Tomorrow, lordship, that.
In the
I have been informed.
in the IA, you are taking the plea that without leave of the court, charge sheet could not have been filed.
Lordship.
The question may arise whether leave can be granted post facto. Such question may arise.
So,
And suppose it is decided in your favor, what would be the
if lordship charge sheet is quashed, even if my petition is allowed and charges FIR is quashed, then entire proceeding will be lordship go.
and if FIR is not quashed?
Then lordship certainly he will face the trial. No other alternative he has, lordship. I am paying for limited time, lordship. Lordship will fix a date for disposal of the case, till then lordship protection.
No protection.
Because otherwise, lordship, it will be difficult for him, lordship.
I'll dispose of the interim prayer today itself. You appear before the trial court tomorrow.
That lordship may not direct, because I have been informed that he is lordship allotted duty of lordship that Boroland election, lordship. He has reached left today itself. For that direction may not be there. Because otherwise he will be in difficult, lordship, because he for official
No.
duty he has left for.
You take leave from the,
That I will.
but this,
My prayer is that lordship may give lordship one chance, lordship, that immediately after vacation lordship may fix for disposal, lordship, and on that day entire case may be disposed of. There will be nothing left after once your lordship decide the entire issue.
no, it may not be easy considering the conduct of the parties.
So here, lordship, the delay is not entirely attributable to the petitioner. It's only.
I am not attributing it to anyone,
Lordship.
but the record before me shows that it is highly contested case and parties are going to Supreme Court.
My lord.
On
Well, perhaps on the fourth occasion, they had approached, the matter was dismissed, and in that application, they had actually contested the jurisdiction, wherein actually the Supreme Court was of the view, which of course is not reflected in the order, that the Supreme Court was in fact about to give a day-to-day hearing in the matter.
So that is not there in the record, so I will not
obviously
comment on
that is what I am
that. I
saying.
have not seen the.
That was the
live stream
observation.
also. But my only prayer is that.
He has
lordship,
been
that-
playing all along. The accused has been all along playing with the court, my lord.
No,
That
if
is
he
my
has
only.
any right, lordship, he is entitled to exercise those rights. Lordship, I am only praying that lordship may fix it on 13 or 14 immediately after vacation. Till then, lordship, he may be protected. Because earlier also lordship given that protection and the case was disposed of within lordship 2 months, lordship. He has not lingered that case. Even we have also argued the case immediately and disposed it of. It is not a case that after obtaining interim order, we try to linger the case. Lordship. That is not the case.
Which case you are referring to?
That session judge's jurisdiction. The lordship protected us and we also lordship contested.
In
the-
this case.
Not in this case.
In
The
it-
earlier case which went to Supreme Court, lordship. He has after lordship granted interim order. He could have lingered the case for a long time, but he has not done so. He has immediately lordship. We have also lordship argued the case and disposed of the case. Here also I am praying. lordship,
What was decided?
that was decided that session judge has the jurisdiction.
Exactly. Section judge has the jurisdiction. That's fallen from his own mouth.
Session judge has the jurisdiction to try a case which falls under POCSO Act. It is not a case that this.
So what was this application challenging?
Challenge was that designated code
okay.
is not there. So I am only praying till 13th protection, lordship. I am not saying that
No,
for indefinite period.
No,
lordship.
no protection. You appear before the court tomorrow.
That he is in official duty, he has already left today, lordship. So I am praying, lordship, that direction may not be there, lordship. And lordship may fix it on 13th or 14th, any date for disposal of the case.
The criminal case, I am fixing it. The criminal petition. It is fixed. It is also listed today.
Lordship.
My lord.
It is listed. I don't remember.
Criminal petition, you may choose a date, consent date.
My lord, any day.
Any date immediately after vacation, lordship, on 14th, lordship.
Choose a date. Heard. In criminal petition, heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. A.C. Borbora.
So A. Mir.
A.
Mir.
A. Mir. You are,
For the informant. For the respondent number 5.
who is appearing for the state? Heard Mr. B. Sharma, learned additional public prosecutor. Also heard Mr. A. Mir, learned counsel for the informant. Let this criminal petition be listed for hearing on
Any day after the pujas, as per convenience of this court.
Khali side,
In that case,
30 October,
30th of October. My lord.
13th or 30th.
30.
30
It will
October.
be too long, lordship. Because even if trial court grants me time, that will not be so long, lordship.
My lord, he
I mean,
is just
therefore, lordship, I am
supposed to
praying for-
appear,
Because I
he
am
explain
not
the charges and after
praying
that
for-
he may not be present, my lord.
Even I am not praying for this before this honorable court to give me 1 month or 2 months. I am only praying till lordship 13th. Lordship is fixing
No,
this matter
till
on
13
14th.
for
lordship.
what?
Because
In this interlocutory application, I'll be passing orders in chambers.
that may be kept pending till lordship 13th, lordship. And matter will be fixed on 13th.
Interlocutory application.
That also may be kept pending.
No,
lordship. Because if
interlocutory.
it does not also give hearing, lordship, he will be in trouble, lordship. Because otherwise lack of jurisdiction and malice is also there in the part. And therefore considering all.
That will be decided in the criminal petition.
Yes, and if trial goes on, lordship, this matter will become, in fact, evidences are recorded.
It
Then
will
this
not
matter
happen
will
on
become-
one day itself, my lord. He is not going to be
No,
sent
I'm
to
only
jail
praying
tomorrow
for lordship
itself.
13th, lordship. I'm not praying for lordship indefinite period of time, lordship, because already your lordship has fixed the matter for hearing.
No, you wait for the orders in the criminal petition. But I'm indicating that there will be no stay. And you have to appear before.
The
The,
direction may not be there.
okay, I'll see how to deal with it. This, I will be disposed of today itself. And
But my prayer was that lordship it may be fixed on 13th or 14th, lordship.
no, hearing is complete.
No, the main case, lordship, on 13th. The main case I'm praying for 14th. Main criminal petition, lordship.
That is all right.
People, আমার সুবিধা আছে নি? Okay, on 14th,
My lord. Obliged, my lord.
instead of what date was given?
30th, my lord.
Instead of 30th, 14 of October. And I will be disposed of, you wait for orders, it will be
Deeply
uploaded.
obliged.
Till 13th, may some protection. That is my limited prayer to your lordship.
Okay.
That is my-
Otherwise, in the main case, the interim order is extended. That
Yes, yes,
interim
that is
order
the-
is this order,
My lord, in the main matter, my lord.
main matter.
The
Well,
interim
the
order is
interim
was
order-
never vacated. Interim order is existence till date.
So
lord.
that interim order, by interim order, what is meant? That
No coercive action.
no coercive
Because
action.
lordship, initially there was a direction not to investigate the matter.
My lord,
And
perhaps,
subsequently, lordship, one direction was there that the victim needs to be medically examined. So this honorable court was of the view that she shall be medically examined and the investigation will continue to that effect. They went to Supreme Court. Supreme Court said that this cannot be limited for limited purpose. They will investigate the entire aspect. So that was the clarification.
my lord,
The
perhaps,
coercive action is.
No,
already
my
there.
query is,
my lord, perhaps after they have already preferred and have been given the liberty in the anticipatory bail application, my lord. Perhaps according to my understanding, subject to being corrected by this court, perhaps that will go, my lord.
Regular bail?
My lord, they have taken regular bail as well. That is my instruction. In the
you are on
trial-
regular bail.
Yes, my lord, in
No,
the
no,
trial
in
court, in the trial
anticipatory-
court, in the trial court, they have, man.
And this secretary bail subsequently he appeared before the trial.
Yes,
court.
my lord, so that
That's
goes, my
fine.
lord.
So you are on bail.
I'm on bail.
Okay.
So that part is different.
Bail granted by trial court.
No, by this honorable court, accordingly he appeared before the trial. court.
And what trial court did
The trial court allowed me to remain on bail.
remain in bail? Okay.
Because anticipated bail was granted.
Okay. Okay.
My lord. My lord. I'm grateful.
Obliged.
Yes.
May I please, your lordship? Lordship, this is matter pertaining to an order passed in on 21/7 regarding implement of the alleged accused, your lordship. Without questioning the wisdom of the view of this court, your lordship, if I may be allowed to make a few of my case regarding.
So
the
for what
implement,
this IA has been filed?
your lordship,
What relief you are seeing or review?
yes, your lordship,
For implement, my lord,
yes,
for implement of partition.
this court,
What was the order?
it's a
Where is the order?
page 11, your lordship.
Mr. Debolal Garlosha was the,
Against whom, my lord, he is seeking an investigation by ED.
Yes, by the.
okay. So why are you not implementing? Why are you reviewing?
Lordship, there are certain points that I would like to impress upon your lordship.
Yes.
Lordship, the alleged accused, Debolal Garlosa, he's a popular influential figure. So he is known to have intimidate people whenever they stand before, they dare to stand before him, your lordship. Then
No, what is your first point? He is intimidating.
people who dare to stand against him, lordship. There is one point, lordship. Then the other,
So you are afraid of impleading him.
lordship, it is petitioner at his own personal risk is taking up the has come
No,
forward.
that is as per direction of this court only.
But then it will,
You are not so moto impleading him. This court directed, therefore you have to comply with the directions of this court.
Your Lordship, that may be so, Your Lordship, but then it would
Yes.
not only expose the identity of the petitioner, but and or the informant. And the whole purpose of the read will be defeated, Your Lordship. That is the limited prayer, Your Lordship. And Lordship, even in the main case, Your Lordship, the respondent has failed to even file the affidavit. They have not filed yet.
My lord, for us, this writ petition is not maintainable, my lord.
They have not yet filed their affidavit regarding that point, Your Lordship.
We need not file, my lord. We can argue the matter, my lord. But the thing is that, my lord, principle of natural justice. He is seeking an investigation against a person who is not before your lordship. Suppose, my lord passes an order, that person will be affected.
Lordship, this is regarding inaction of the ED, we are not bringing the alleged accused before this court, we are not. We are filing this writ because of the inaction of the ED, not because of the alleged accused.
My lord, petitioner has to understand jurisprudence of criminal law, my lord.
And there is a question of Article 21 also, safety of the informant.
No, how by impleading him, your safety will be jeopardized. Otherwise, you have filed this.
His identity will be exposed and.
How it will, you are the petitioner in this case. It is, the cause list is in public domain. The proceedings are live streamed. Then how you are not exposed? You have not prayed for
Protection,
any protection that your identity should be concealed.
concealed, my lord. Moreover, my lord.
Moreover, Lordship, but then we have not come against the accused. That is the question. Otherwise, we would have made that prayer. We have come against the inaction of the ED, not against the accused. That is a limited point.
My lord, this is fundamental. When
Okay. Yes, what you want to say?
my lord, the thing is that any investigation of PD, my lord, doesn't work that way, my lord. If you go by PLMA Act, my lord, the thing is that, my lord, there has to be a, my lord, schedule offense. Schedule offense will derive from an FIR. They have to file an FIR against the accused, either with the police or CBI. ED, my lord, comes in later. We, from that FIR only, my lord.
No, we'll dispose of this interlocutor application
My lord,
first.
my lord. If he doesn't want, my lord, fine.
And thereafter, because he has made a prayer.
My lord will dispose of this IA, fix the matter any day. The main criminal petition will, my lord.
I'll pass the orders in chambers.
My lord is keeping alive that criminal petition.
Criminal petition will be fixed on a different date
My lord.
after vacation,
My lord.
and this will be disposed of.
My lord will record my submission now.
Yes.
And for the ED, my lord.
You're for ED.
Enforcement Directorate. Arthur for ED.
Yes. Okay.
My lord, your lordship rising, my lord. Item 27, my lord, your lordship already had, my lord, your lordship directed me to submit a short submission, written submission. I have prepared, my lord. Item 26, because my lord warrant is there, my lord. Your lordship had twice, my lord. Either your lordship fix on Tuesday, my lord, or my lord allowed to submit the written short submission.
Item number?
27.
Who is the other side?
Other side, Mr. Sharma is there today. Is not. last occasion he appeared.
Who?
Mr. N. Sharma, Yes Bank, Standing Council of Yes Bank.
You have prepared your written objection
My lord, yes.
on Tuesday.
Tuesday.
Tuesday, you submit your written
Well,
objection also.
Regarding item 25, I'm so unfortunate that it was not reached to your lordship today. But may I pray to 20 on Monday, my lord?
Monday, you will be standing at this time exactly in similar manner, praying for another day.
Man is behind the bar, that's why. Statutory appeal. Act,
Because on Monday, it will not be listed at the top of the list. It will again, if I allow you on
Well,
Monday,
I'm hopeful that it will reach to your lord Monday. If you will kindly allow me.
no, let the registry finalize. It may be list, 1 week time is still there. All leftover matters, the registry shall finalize the date. I have already requested the registrar bench to accommodate the leftover matter wherever urgency is there before vacation.
My lord, only 24, it ought to be 25, correction of an order Monday,
Which order?
item 71, my lord. Bail granted, my lord, only the.
71, I will pass orders.
My May I please, my lord? In item number 24, my lord, the petitioner has been convicted under section 326 and subsequently he was sentenced to 5 years. My lord, may I let this matter fixed on next week, my lord, any day.
That I have already stated that registry will give you date.
Give you that.
I will not fix. All matters will be listed by registry.
Lordship, in my case, Lordship, some urgency is that tomorrow is the next date, Lordship. Here is just a issue is that, Lordship, that husband and wife is a 498 case. There's compromise has been done and a criminal petition has been filed jointly. And in the meantime, the honorable court has directed that from lawyer court, a report has to come, whether compromise has been done or not. Ultimately, report has been come, Lordship. So, report reveals that it is voluntarily matter has been amicably settled. So, Lordship,
Item number?
20 and 21. 20 and 21 is a joint petition, and 21 is the other in-laws, Lordship.
Okay, I'll go through the records.
Highly request.